My lord, may I have your lordship's kind leave to mention, my lord, for correction of your lordship's order, my lord. My lord, let it appear as to be mentioned, my lord. Correction of the date, my lord, and
Date.
my lord, correction. And my lord, one contempt application, my lord.
One by one.
My-
Have you this correction? Have you given notice to your other side?
My lord, I shall give notice. My lord, let it appear as to be mentioned tomorrow, my lord, or as your lordship desires.
Give a notice. Yes.
Tomorrow.
Give a notice. Give a notice. It will come as to be mentioned.
My lord, my lord, my lord.
I'll
And my
to
lord,
be mentioned.
My lord, may I be permitted?
the contempt application, my lord.
Contempt of whose order?
My lord, your lordship's order, my lord.
With my brother.
Yes, my lord.
Fresh contempt.
Fresh contempt.
My lord, may I be permitted to mention a joint compromise petition? My lord, it's a land acquisition case. A compromise has been obtained between the state and the parties.
Which matter?
My lord, it is a land acquisition matter.
Item it is appearing.
My lord, it is not appearing in the list. My lord, it has been filed just before the vacation, the compromise petition. But
Did we hear it earlier?
My lord?
Did we hear it earlier?
No, my lord. My lord, it is an appeal.
WPLRT
No,
or
my lord.
mandamus?
My lord, it is a mat. It was a writ petition.
Have you given notice to your other side?
My lord, it is a joint compromise petition and the mention slip is also joint. It has been signed by the state advocate as well as me as an advocate on record.
State কি করে compromise?
My lord, it was a land acquisition case, a writ petition with yes, ma'am.
To be mentioned
My lord,
দিয়ে দিও এটা।
matters joint.
পেয়ে গেলে day after tomorrow.
My lord, a cabinet meeting is scheduled to be held in on 22nd of November. My lord, if the hearing could be concluded before that.
22nd
My
November.
lord, any day this week.
Yes, it will be. Give it tomorrow. Give it to be mentioned.
Deeply
Give
obliged.
notice to your other side.
My lord, may I be permitted to mention one matter, my lord, for application in connection with the review application. This review application is pending before your lordships as item number 153 of the monthly combined list, my lord. That order was passed by your lordships, my lord. And my lord, the urgency is that, my lord, in this juncture, at this juncture,
Are you mentioning upon notice?
my lord, this is application, my lord. This is application in connection with the review application.
Right. Who is your other side?
Uh,
Who is your other side?
my lord,
Give a notice to him and come and mention.
my lord,
What is the urgency?
urgency is that, my lord, the petitioner, my lord, applied for the transfer in from Pakohat Degree College, Malda to Sadhana Chandidas Mahavidyalaya, Bankura, my lord. That time, my lord, your lordships rejected the matter as the 5 years has not been completed. Now the 5 years has been completed, and another thing is that the person.
So what is the urgency?
My lord, the urgency is that, my lord, the person who is, my lord, recommended for transfer in that college, Sadhana Chandidas, she has not been, my lord, she has not joined in that post, my lord. Now the post is vacant. Now they are in a hurry to appoint that person in that post, my lord. Now this vacancy will be, my lord, my lord, gone, my lord. That is the, my lord, problem, my lord. That post will not be vacant, my lord.
So it is a fresh cause of action.
No,
When we dismissed it, it was on the ground that he did not
my lord,
complete 5
my lord,
years.
as my lord, the review application is pending, my lord.
Maybe review is not a continuation of the original proceeding.
My lord, there is some point, my lord. My lord, kindly here, my lord, kindly, my lord, make me my lord, my lord,
Which is the item
item number 153, my lord.
of the combined list?
Combined list, my lord. Review application has been my lord, filed long before, my lord. It has not been heard, my lord. Some indulgence, my lord, your lordships, kindly.
But it was called.
It was called on. You did not appear. No, we have first day it was called on. Thereafter, we again started from the beginning. Up to 81, it has been called. You give the application number, it will be tagged with the review application.
If your lordships kindly fix any date, my lord.
Sir, what is the urgency? Urgency, you are saying that that 5 years period is now over, for which you have sought for review. That gives a fresh cause of action
The
to you.
review application already filed, my lord, for reviewing the order passed by your lordships. After that, my lord, this application has
Day after tomorrow, ওখান থেকে to be mentioned করে দাও along with this application.
yes, my lord. I'm grateful, my lord.
You have to. Who is your other side?
My lord, this College Service Commission, my lord, Mr. Panda is appearing, and
I don't know. Unless
I'm
unless
serving.
you complete service, we
No,
are
no, my
not
lord,
here.
I shall serve. My lord,
Petitioner has been dismissed from his
Which
service.
matter are you mentioning?
My lord, it is FMA 428 of 2020.
Are you mentioning upon notice?
No, my lord.
Please give a notice and mention on
It's a fresh admission. My lord, during pendency of this appeal.
mandamus appeal or WPLRT?
No, my lord, mandamus.
Yes, what has happened?
My lord, the petitioner had been dismissed from his service, and during pendency of this appeal, he again rejoined the service. Something is, my lord, arrear salary is due.
Arrear salary?
Arrear salary and other benefits.
Have you filed an application to that?
Yes, my lord.
Have you served?
No, my lord, it's a fresh matter.
Connection with the main matter. Who is appearing in the main matter? Who is your advocate in the main matter appearing for the respondent?
My lord, this is a fresh appeal, my lord, it is not service.
Appeal is fresh or the application is fresh?
Appeal, my lord.
When have you filed the appeal?
The appeal is 22, my lord.
When was the return? 2022.
2020.
It was never heard.
No, my lord.
Any application was filed in connection with?
Yes, my lord,
the
for
appeal?
appropriate order section for application for condonation of delay.
That application has been served.
No, no.
that-
You know, application.
Your application I hate it.
that-
Your Lordship, I'm praying for the inclusion in the matter. It was told that it will appear after the vacation, but it is not mentioned in the list.
Which matter?
So,
Application, hearing,
it's a
tribunal application, which?
Your Lordship, it's a WPA matter.
Huh?
Your Lordship, it's a WPA matter.
I couldn't follow. Group 2. WP. What is the number?
WPA 4280 of 2014.
WPA is writ petition. Which item you are mentioning? Is it in the list?
No, Your Lordship. It was told that it will appear after the vacation, but it is not there.
Is it a mandamus appeal or it is a WPLRT? What is it?
Your Lord-
স্লিপটা নাও তো বের করবে না কিছু করবে হ্যাঁ
Appeal.
so where is your notice? You have not served. Have you served?
No, my lord, we have not, sir. My lord, there
Serve and
was
mention.
direction. The matter was listed immediately
Please
before.
serve a notice and mention.
Yes, my lord.
Yes, call the list.
Take notice later.
Yes, Lord, I'm for the petition. Lord, your lordships had extensively heard this matter, my lord. The interim order as that was granted earlier, it existed till, my lord, 19th of February 2024. My lord, subsequently, my lord, it was not extended. As a result whereof, my lord, the honorable tribunal, my lord, decided to proceed with the contempt application. In the meantime, certain developments, my lord, the honorable Supreme Court had taken up the issue, my lord, and the basis on which, my lord, the honorable tribunal had passed this order, my lord, this was stayed. Now, my lord, if your lordship kindly grants extension of if your lordship kindly extend the interim order, my lord, that was existed till 19th of February 2024, my lord.
So
Then,
how can we extend it today?
because this was a parted matter.
So you ought to have mentioned before us
My
that
lord,
it has expired on 19th
my
February.
lord, since the honorable division bench is in season of the matter, my lord, this was.
Why? We were present in court, Mr. Bose.
Yes, yes, your lordship.
Then-
No, my lord, kindly, my lord, because
you
this
go
was.
before the regular bench.
My lord, this is parted, my lord. Your lordship had
Will,
extensive.
we
Lord,
will
kindly
say
do
it
not.
shall
My lord,
not
your
be-
lordship, kindly, my lord, your lordship had extensively heard. It is not a question that this was never heard, and this is on account of change of determination. Your lordships are releasing the matter, my lord. Kindly have the charity to consider. This is a case, my lord. Both the writ petitions.
Sir, what have you? Are you mentioning upon notice? Have you mentioned this
Yes,
matter?
yes.
Show us the notice.
Yes, notice my
Show us the
my-
notice
affidavit of service. Judge ke din.
that you are mentioning the matter. When did you mention the matter?
This was mentioned much after the order. next, last Thursday, my lord, this was mentioned. This was directed to be
Mr.
posted.
Basu, first of all, we cannot extend the interim order because after February,
It is not a question of,
Yeah, just a
yes, yes, my
till
lord.
the month of November, you have not, it is a, this is not a proper practice, Mr.
No,
Basu.
my lord, it is true.
Just because we admitted the matter and granted an interim order, your advocates on record have
My
never
lord, it is a
mentioned-
question, my lord, kindly, my lord, just, my lord, kindly, my lord, this is a question of, my lord, reimposition of the interim order, my lord. It is not a question, extension is not a proper term, my lord, in the present context. My lord, we have also said, my lord, it is a fresh interim order.
Statement will not do. You know what is to be done. When you have kept quiet for 7 months, you know what is to be done.
Now,
It
my lord,
was
this
passed in
application,
January.
my lord, kindly sees the application we have said, my lord, an application for extension of, this is the prayer, my lord, kindly sees the last page, page
Of what?
6.
Of what?
In circumstance of can one graciously please to extend
Can
the
one? Can one is,
can one page 6 my lord.
where is can one?
Can one টা ছিল
No, can one.
it is
Application for reinstatement.
my lord listed. This is showing my lord number is
Application for reinstatement or.
reimposition and my lord fresh. This is the order. Application is saying my lord
Wait,
reimposition.
let us get the application.
Who appeared on behalf of the respondent?
My lord respondent Mr.
Can one,
Mr. B.R. Dash. আছে পাওয়া গেছে ক্যানটা
You give a notice to B.R. Das or K.K. Ghosh.
ছিলাম মামলাটা।
You give a notice to B.R. Das or K.K. Ghosh. We are keeping it tomorrow.
day after tomorrow my lord because my lord because because his chamber is the central administrative tribunal we have to say.
Oh, okay. Yeah.
Deeply obliged.
Day after এটাকে এভিডেভিডেন্স সার্ভিসটা ফেরত দিয়ে দাও।
হ্যাঁ, কি এভিডেন্স সার্ভিস রিসিভ?
ক্যানটা এনে ডে আফটার টুমোরো ক্যানটা ট্যাগ করে দিয়ে দিও।
Not kindly record an order.
হোয়াট?
That is to be recorded.
রেকর্ড হোয়াট অর্ডার?
That you the non appears
পেয়েছো ক্যান? হ্যাঁ।
page 6.
After
Page 6 prayer.
extend the interim order.
And then and order fresh interim order of stay. It should be Millard, additionally Millard reimposition. Millard, the court can mold the prayer Millard relief.
To correct your misgivings. Court will pass order to correct your misgivings. 6 months you were sleeping and come with an application. An application for extension of interim order being Can 1 of 2024 has been filed in connection with the
But I appeal for the
কি পেপার বুক কেন?
My lord, I am for the
Why it has come as to be mentioned, Mr.
My lord, last occasion my London friend was out of station. Your lordship wanted to ascertain whether the district magistrate who has been directed to serve upon the private respondent has been done or not.
my lord, it has been served.
You are for the state.
Yes, sir. My lord,
None appears for the private respondents.
That's, my lord, time and again she was served. She didn't appear. Since her appointment is under challenge before this appeal,
Whose appointment?
my lord, appointment of private respondent number
Onita Sardar,
9 and 10.
9 and 10.
no, only 10 added respondent.
We are Surya,
Suraiya Khatun
Suraya.
Yes.
and Anita Sardar.
Anita Sardar, my lord, she represented, she got appointment elsewhere. She is not interested in this petition.
So have you, there was a direction upon the DM to
Intimate.
serve upon 9 and 10. Have you served?
Now Suraya Khatun has been appointed.
In my place.
Oh, that Abad Bhagwanpur.
Yes, Bhagwanpur and Abad Bhavan.
You applied for
Bhagwanpur, I was called for interview in Bhagwanpur. I was selected for Bhagwanpur. My name was impelled in serial number 3. 2 could not be appointed because of their unwillingness. I could have been given appointment. Subsequent to this selection, while the matter is pending before this honorable court, in 2020, first selection process started, and this Suraya has been appointed in my place.
You are original residents of Bhagavan.
Bhagwanpur. That is the finding of the London trial court. Your lordship.
Achha,
kindly see.
where have you given the appeal papers? You have merely caused service of the appeal papers. You have just communicated the order, not the appeal papers.
Your lordship, kindly peruse my.
Huh?
there is a writing appellate copy file up.
Appealer copy পাইলাম।
They have been served.
এটা কোথায় দিয়েছে? সার্ভিসটাই তো হয়। Attached here. এটা কে দিয়েছে? এটা সিএমওজি সেক্রেটারি ডিএমকে পার্টি। সার্ভড।
এটা তুমি দেখাবে তো যে অ্যাপ্লিকেশনটা করেছে
হিয়ারিং এ আসবে
ওর অ্যাপ্লিকেশনটা।
আরে what, where do you have served the have you served the paper book was filed when?
My lord, thereafter the paper book has been filed after this order, my lord.
So along with this you have served the the appeal papers have you served?
Yes, my lord, total appeal paper.
Where is it written appeal papers are served? Accordingly, copy of the order and appeal being such and such is enclosed. Pursuant to the earlier order passed by the coordinate bench of this court.
They have all
Twice I have served.
Yes, also, sir.
Already the appellant already.
Both of you cannot speak.
No, no.
Anyone make up your mind.
Already the appellant already.
We are not concerned with that. We are concerned with the compliance of the earlier order. Earlier order, have you seen?
Only the paragraph 4, my lord, state to inform private
Because
respondent.
pursuant to the earlier order passed by a coordinate bench of this court, service has been effected by the respondent number 5 upon the respondent numbers 9 and 10. Let the documents towards such service, as produced, be kept on record. Mr. Islam, learned advocate appearing for the appellant, informs us that the matter is ready for hearing and informal paper books have already been filed. Stop in view thereof, list the matter for final hearing in the combined monthly list of December 2024. Stop. The petitioner, appellant করে দেবে, বুঝলে তো, petitioner সব জায়গায় ওটা appellant করে। The appellant is directed to intimate this order to the respondent numbers 9 and 10 and to file an affidavit of service on the returnable date. And file an affidavit of service. Immediately intimate this order to the respondent numbers
9 and 10.
9 and 10. With the first paragraph, let evidence as and তারপরে একটা প্যারা ঢুকিয়ে দাও, in spite of service, no one appears today on behalf of the said respondent numbers 9 and 10. Yes.
My lord, one thing I want to draw your lordship attention, my lord. During the pendency of this writ petition, it was dismissed for default. But in the entire order sheet, my lord, the restoration order is not there, my lord. But this appeal was dismissed for default in the meantime.
Yes.
Restoration petition was filed, my lord. But in the order sheet, I do not.
Was it dismissed?
Dismiss was made on.
Appeal was dismissed for default.
When?
Thereafter,
My lord, order dated 24/6/2024.
24/6.
Yes, my lord.
So it must have been restored.
My lord, but there is no order, my lord.
application in time, but the learned judge was of the view since I will decide on merit. Restoration is immaterial. I will dispose of the restoration at the time of final hearing.
But
That
there
was
must
the
be, but there must be an order, my lord. In the
that should be restored fast.
there must be an order, but in the
Your lordship
entire
kindly
file.
restore it also today.
So, my lord, it will be technically mistake if it will be not restored.
Where is your can 3, Mr. Islam?
Well, that is right.
Can one.
Have you served this restoration application upon others?
Yes, my lord, we have got.
Affidavit of service also there.
My lord, there is only no order in the file that I want to draw to your lordship attention.
Where is your service of the restoration application?
May I? That is affidavit of service I have filed.
So when did you file the appeal? Restoration was served upon you.
Yes, my lord.
It was served upon you.
Yes, my lord.
Affidavit of service also.
When was it dismissed, you said?
My lord, 24 June 2024.
আচ্ছা আসুন। When প্রথম প্যারাগ্রাফে লেখো, records reveal that the কোথায় কত তারিখে ডিসমিস করেছে বলে? Records reveal that the appeal being MAT 1719 of 2022 was dismissed for default on 24th of June 2020 by an order dated 24th June. The records reveal that the appeal being MAT such and such, as well as the application filed in connection with the same being Can 1 of 2022 were dismissed for default. Stop. The appellant thereafter filed a restoration application being Can 3 of 2024 and service was effected upon the respondents.
তুমি দাওনি আমাকে, তুমি শুধু ক্যান 3 দিয়েছো।
ঠিক আছে, stop. Respondent. In spite of service, comma, no one appeared on behalf. কি বলেছো? আগে একটা বলা ছিল না? আচ্ছা, এটাতে এভিডেভিট অফ সার্ভিস ওয়াজ সার্ভড।
স্টকটা হয়ে থাকে, এটা নাহলে টেকনিক্যালি
তুমি বলছো না অ্যাপিলে,
না, ওটা তো পরে লিখলে, পরের আগের প্রথম প্যারাগ্রাফে লেখো যেটা বললাম এখন। হ্যাঁ,
আমার তো কোনো লাভ নেই, এই জন্য বললাম।
হ্যাঁ, were dismissed for default on 24th June 2024. তারপর restoration application being cancelled and upon all the response. Upon considering the we are satisfied with the explanation given towards the absence of the learned advocate of the appellant before
অর্ডারটা শুধু চিঠি করে জানি।
Grateful to your loss.
Item number 3, I am for the appellate petition.
তুমি আছো?
3 নম্বরটা তাপস বেরা,
হ্যাঁ
কোনটা? তাপস
সন্ধ্যা ভট্টাচার্য।
সন্ধ্যা ভট্টাচার্য, আইটেম নাম্বার 3 সন্ধ্যা ভট্টাচার্য। এটা রেজিস্টার করছে কোন ডিট?
সন্ধ্যা ভট্টাচার্য আপনি?
আমি সন্ধ্যা ভট্টাচার্য
হয়ে
My lord,
সন্ধ্যা ভট্টাচার্যের হয়ে?
appellant is ill. She has executed a power of attorney in my favor. I am her son.
How
I
can
am
I
praying for allowing me for conducting the hearing, relying on the section 32 of the Advocates Act. And section 32 of the Advocates Act.
বস না।
34 Advocate Act.
On 20th August, my lord, the appellant took adjournment. It has been recorded in the order sheet. On 20th August, the appellant took adjournment to engage in advocate.
No, my lord. Appellant has no faith on any professional. So
Oh,
she has
I see.
interested upon me. Her condition is very pathetic. She is leading life unfed with illness. She has not
এগুলো বলে কোনো
getting
লাভ
any
নেই
pension.
এগুলো বলে কোনো লাভ নেই
According to section 32, my lord,
Four, the
আপনি
one
অ্যাপিয়ার করতে
person
পারেন
can-
কিনা দেখুন
one person can empower his son or relative to appear before a court. Please show that.
yes, I am relying on the judgment of Honorable
আগে
Supreme
আইনটা
Court.
দেখান কি বলেছেন আপনি আইনটা দেখিয়েছেন আগে
I
আইনটা
have-
দেখান যে আপনি
I have the
অ্যাপিয়ার
copy,
করতে
ma'am.
পারেন
From 34, you show that any person can
আমি তো
empower
কখনো
his
শুনিনি
relative,
ফার্স্ট টাইম
any of his relative to address
My
the
lord,
court.
I'm relying on section 32 of the Advocate Act, not 34.
32, read the relevant portion.
Yes. The appropriate
32, you said.
32. Power of court to permit appearance in a particular cases, notwithstanding anything contained in chapter, any court, authority or person may permit any person not enrolled as an advocate under this act to appear before it or him in any particular case, my lord. I am relying in this regard the judgment of the Honorable Supreme Court in S. Ramachandra Rao versus S. Nagabhushan Rao and others. I am giving a copy.
কি কপি
What-
দিচ্ছে
what is the
আর বইটা একবার
proposition?
দেখি তুমি আছো এই ম্যাটারে
What is the proposition?
মানে ইন পার্সন অ্যাডভোকেট অ্যাসিস্ট করছে যে বলছে না না যে বলছে যে অ্যাডভোকেট
Yes, my lord, kindly
প্রফেশনের
come.
উপর তার কোনো ভেদ নেই
My lord, kindly come. Kindly come on page number 30.14.
ইন্টার প্রফেশনের উপর তার কোনো ভেদ নেই
Page number 30.14.
That's why kindly hear.
This is the case where the appellant sought for appearance through his wife. His wife was an enrolled advocate. Yes, I am also enrolled advocate. Now the-
Enrolled in this bar.
No, I have just got my enrollment number, but not yet started practice. This is my mother's. It is our own case. So my mother has trusted upon me because due to the professional negligence of the previous advocate, our case that is my mother's case got dismissed. So she has no faith on any professional at this moment. My lord, kindly find. Yes.
4,800 and odd days delay my
Yes.
my well I shall find yes
My lord, I have a little submission. Appellant wants to adduce some new facts with the restoration application and delay condonation application. So kindly allow her to give a supplementary affidavit, short supplementary affidavit, 2 points, my lord, only, which has not been adduced in the delay condonation petition at the present situation. So kindly give a liberty to file a supplementary affidavit. Yes, my lord, I will enter into the fact of the case. Yes. Uh, yes, I have. Yes, these are the two. My lord, Yes. Yes, yes, regularized. Actually, the date of effect in the post of health assistant female, actually the date of effect in which she worked, that is the health assistant female, was not given properly. The date of effect was given from the date of preferring the writ petition, which has no reasonable nexus with the actual facts and circumstances of the case, my lord. Yes, yes.
From when do you want the service to be?
Actually, the service effect should be from the year 1977. Actually, it was given from the date of preferring the writ application, that is 22nd April 1985, my lord. 85. From the year 1977, date 28 November 1977. 7.
So when did you do there?
Actually, she retired from 30th September 2008. 8. No, no, nothing. 30th September 2008. Yes. No, no. Actually, she joined, my lord, on 21st January 1967. I'm entering into the brief fact. No, regularization was made as usually on the basis of the finance department notification. 1st June 1979.
When did you retire?
She retired on 30th September 2008.
But you have pension.
No, nothing. No pensionary benefit has been given. No pension has been sanctioned. There are twofold aspects. Actually, she was ill.
You are my pensionary benefits and everything. That
No, my lord. That order is only for settling refixation of her scale and the effect. This writ order. Yes. I have enrolled, my lord.
So this order is in your favor.
Yes.
After 25 years.
For the rectification of the date of effect, my lord. Date of effect.
After 25 years for rectification.
No. Appeal was preferred in the year 1990. The number is 1131 of 1990. FMA.
What?
Yes. I want, my lord, I want in the appeal either to fix her service benefit in the post of health assistant female from 28th. No, actually, my lord, they have given benefit on the basis of this order. There is no. Actually, my lord, no, appeal has already been preferred. My lord, this order, the effect of in her post.
My lord, I also, my lord, wanted to take instruction in this matter because it failed from your lordship on the last occasion, subject to, my lord, maintainability. Now, my lord, because there are, my lord, the 4,800 days delay. So far, now, my lord, another point is, lordship, that so far the interpretation of this, my lord, particular section 32. Lordship, kindly. Kindly consider one thing. Now, my lord, my lord, the liberty has been given to, my lord, appear in person in respect of one's own case.
No, no,
In
no, my lord.
person, admit. আপনি যখন বলেছেন আমি একটা কথা বলিনি। Very good. Now, my lord, he is now trying to, my lord, take benefit of section 32 in other way. Forget, all right, my lord, all right. Now, my lord, as it appears that it has been, my lord, recorded in the order sheet of the appeal court's order till it was, my lord, dismissed, that there are, my lord, the two checks handed over in court with regard to the compliance of the, my lord, the court's order in the appeal court. Thereafter, my lord, he papered as it appears from the averment in the, my lord, section 5 application and, my lord, the application for restoration. These are the two copies, my lord, I obtained from the, my lord, the GP office, which is served upon the GP office, section 5 application and restoration application. Now, my lord, as it appears from that, no, section 5 application and restoration application, these two applications is served in the office of the, my lord, the GP, and, my lord, I, on my turn, I received it. Now, my lord, no other copy. Now, my lord, may I tell one thing? Now, my lord, the contempt was filed as it appears from the averment herein. That contempt disposed of, it also appeared from the averment. Contempt filed for not compliance of the order. You have already taken. No. And the section 5. My nothing survived. Now, another thing, and on another thing, I, my lord, tried to, my lord, sought for instruction, but it appears that, my lord, in which department, my lord, she had been in service till his, my lord, the service period tenure. My lord, that is not clear from these two, my lord, the papers. So, my lord, my lord, because only health assistant in, my lord, department, that would not help me. So, a particular, in which department, otherwise it is very difficult, who, my lord, retired in 1998. Yes.
My lord.
My lord.
My lord, supplementary affidavit is for the clarification or clarification for the delay. That question has been arised. So for the delay of 4,829. Yes, there are 2 points, my lord, which should be incorporated. Okay.
And, my lord, exchange the particulars.
My lord, there
and,
are,
my lord, kindly,
regarding the appeal, there are two aspects, my lord. GP has said.
The objection you think about the
lawyer,
there are twofold aspects, my lord. One is appeal, another is release of salary.
my lord, first of all, my lord, may I tell, my lord, as it appears from the averments and the prayers made herein, my lord, their issue was not with regard to pension. First of all, issue has never been with regard to pension. Now, my lord, when the writ petition was filed, as I have understood, that the writ petition was filed with regard to certain, my lord, the refixation of his salary and, my lord, regularization. Now, my lord, regulation has been given effect to, as per order of the court, my lord, from the date of the filing of the writ petition. Now,
This gentleman, tell us, Who will, you are
You,
who will explain these things?
you kindly consider during service tenure of your mother, one dispute arises regarding fixation of pay as per ROPA rules such and such, and regarding payment of salary for that period, yeah, and house rent allowance. That was disposed of by a writ petition. Order was not complied with. One contempt application was filed. That has been disposed of, contempt application. Disposed of why? The court observed that order complied with. You have challenged that said appeal. In the
No, my lord.
meantime, your mother.
Give me a little time.
Okay, okay. In the meantime, your mother retired from service. Now 16 years already left. Now you are challenging this order and you are pursuing this appeal.
No, my lord.
Whether it would be beneficial to you, or there would be another litigation should be done
Yes.
for
Let me enter.
getting the retirement benefit and pension.
My lord, let me enter into the fact. Actually, writ
If you
petition.
want that pursuing this litigation, you will get pension or other retirement benefit, that would be a fertile exercise.
No, my lord. Actually, there are twofold aspect in this case. First, FMA number 1131 of 1990 that was preferred against the judgment of the writ court for giving proper effect of her service benefit. That was wrong.
You cannot agitate that in appeal. That is why you prefer contempt application.
No, my lord. No.
No, then go back home. You don't try to,
My lord.
don't try to understand, then we will dismiss your matter.
No, my lord.
Don't waste our time.
Okay, then can application was filed within that appeal in which the state respondent withheld her salary. She did not got her salary from
Now,
July.
here only in this appeal we shall look whether the disposal of the contempt application was correct or not.
No, contempt.
You cannot go beyond that.
I would like to give a
Now,
brief
you are
synopsis.
that your mother retired, not getting pension, no retirement benefit.
Disposal of contempt merged everything.
That is the main matter to be addressed
Yes.
by you.
Her salary was withheld from the year 1990, and two checks which he is referring was for a period of salary.
When you come with the supplementary affidavit.
Supplementary affidavit as you direct.
আপনি বলুন আপনি কবে আনবেন?
Last week or
Don't understand state of affairs. You do not understand what is the sequence of this.
my lord.
Government will take back that benefit.
My lord,
Not understand problem.
actually,
Starting from which
Bardhaman University,
what was
2021.
thereafter restoration application?
No, my lord. Actually, the advocate who dealt in this matter, he died. He always convinced my mother that when the matter will come in the list, your matter will be raised. But whenever she visited her, 75. Yes.
You don't have any brothers and sisters. What?
Actually, I pursued in a company job. Thereafter, I joined LLB, and thereafter passed LLM.
Yes, on the strength of the power. Let me say God. So what is just happy? So please for me. Find this happy. Which
the instruction I have to take, no office, nothing mentioned therein. Very difficult. Where did I always, but nothing is mentioned therein, except that the health assistant. কোথা থেকে খুঁজে পাবে বল? Get Philip.
Or I am for filed affidavit of service. The impugned order is of my lord 11th July 2024, my lord, which has been passed by the learned single judge at page 30. After
present topic has been for challenging and ordered dated. 1535.
I appear for the appellant. There's an order passed on 5th September 2024.
we are filing report, my lord, pursuant to your lordship's direction.
My lord, I am appearing for the writ petitioners who are the respondent number 1 to 8 before your lordship.
The Lord, of course, may file the report, but they were supposed to file it within 3 weeks from 5th September. The purpose was, if any of the parties wanted to file exception, they would file it within a week.
My lord, no copy of the report has been served upon.
Well, I am a little more fortunate because I've been served on 14th,
Yes,
which
I am
is
very
the
unfortunate, lordship.
14th, which is just before this vacation. So, but we are unfortunate. The councils have not received it.
You not received it.
My advocate had received on 14th, And therefore these holidays were there, 15, 16, 17, is not come in my hand. So I don't know whether I'll.
All right, file your reply, a exception. When do you want to file your?
No, my learned,
No copy has been served.
who is the
But
more
for
who is the more aggrieved party?
I am
The
for the
writ
writ
petition has not
petitioner's
been
lordship.
served at all.
I am for the writ petitioner's lordship. No copy has been served.
No, no. I have served upon him.
Yes.
No, I told your lordship, I am fortunate than the writ petitioner that I received it on 14th, but we are unfortunate. We did
Very
not.
good, very
receive.
good. Now you have.
Now only there is
given you
only
the
one
copy.
issue. There is only one issue. The interim order will expire. I mean, that is why your lordship made it till November end. I don't know whether all these things are cutting it too fine. I mean, we are.
File exception within 1 week.
If I want to, I will.
Go through.
Yes.
We are.
Yes, I will. No.
Well, let me file.
They are
let
the
me
more
file an
aggrieved party.
exception
You are
to the-
for whom?
I am for the writ petitioners who are the
Respondent number.
1 to 8.
You are the writ petitioners,
Right.
respondent 1 to 8.
Right.
Now, who are the added persons?
Added person, they are the owners.
They are the
Erstwhile owners.
Erstwhile owners.
From whom my
No,
clients purchased.
they have been served. They are never appearing.
See, Mr. Saurabh Sen appeared.
they appear.
Appearing is appearing.
Okay. I'm
For
sorry.
21, Lordship. Respondent number 21.
One of them.
One of them, Lordship. He is
One of
appearing.
them is.
One of the 21.
Ashu.
ওদের নাম্বারটা একটু দিয়ে দাও, ওদের একটা কপি দিয়ে দাও। সৌরভ সেনের appear?
হ্যাঁ।
ও, তোমাদের সঙ্গে আছে। সৌরভ সেন তো
তোমরা আমায় সাপোর্ট করছে। ও আসে তো দেখতে পাচ্ছি।
নাম্বারটা দোকানে আছে? ওদের নাম্বারটা লিখে দাও।
Mr. Bandyopadhyay, learned advocate,
Hmm.
appearing for the state respondents.
November.
Well, lordship has kept it third week of December.
3 weeks after, 3 weeks.
There are so many marriage ceremonies. My stomach will.
Let the matter come in the list. If your stomach creates problem, we will.
I am very sorry to submit, Lordship. Day by day, interim order has been extended, Lordship. I am very sorry.
Use an
Very well,
exception.
we will do it.
Is- we are hearing it for the first time.Use your exception, let it appear, you remind us. Yes.
Lordship.
Right. It was on a lighter note.
Yes,
We
next.
all have problems, my lord.
You have got the copies now.
No, patient.
Not
You have not yet.
Not yet.
Mr. Bandyopadhyay, give a copy to what exception file koreni? You have not filed the report.
He filed, but no copy has been served.
We have already recorded that you have given. So you bet. Yes, next.
আমাদের annex
Yes,
দিয়েছে?
next. Item number
6, my lord, Mr. Owen Banerjee is appearing for the state. Due to his illness, he has not come today, my lord.
Lord, in that matter, my lord, remember the compensation award was not given. The other co-sharer was disbursed the compensation and the
When will he come? Tell us a date. We are becoming embarrassed, na? Repeatedly it is coming.
on their prayer, the matter was fixed today. On last Monday, the matter
He is
was.
sick, sir. He is sick, he has not come.
And my lord,
Come on Thursday. Thursday. Yes, next.
Seven Millard, I am appearing for the private respondent.
Only in this matter, I am appearing on behalf of the petitioner.
In this matter, I appear for the state.
For the petitioners.
For the petitioner. That is the impugned order, that is the last page.
30. Is our.
That is 19th April 2020.
Just.
Instruction copy.
Yes.
Yes. My lord, my made a representation, that is page 91. Statement. For correction of record of right, we are the legal heirs. Up to attestation stage, my name was recorded, and thereafter, that land was transferred by one of the legal heirs, the entire plot. For this reason, their names were recorded. For this reason, I made an application before the authority concerned for correction of the record of rights, according to section 50, that is the record of revisions. That is page 91.
So have you served upon the private respondent?
Yes.
Served?
Yes.
You
Private
are
respondent.
Yes. Then you filed an application for recording your name.
For recording name, that is still pending. Thereafter, I moved an application before this tribunal, and tribunal, that is passed an order that there is a civil dispute, you go before the civil court. Only for correction of the record of rights, section 50. Nothing more, nothing less. Page 91, that is my representation. Entire plot is 19 decimals.
Where is that application of yours to the BLRO?
Page 91. Page 91.
My lord, may I? My lord, last occasion, my lord, I have handed up 2 instructions, my lord, where, my lord, I have shown that the petitioner has tried his luck in before the writ court. They lost. Thereafter, appeal court, they lost. My lord, in that writ petition, the subject matter was that private respondent got the conversion from the appropriate authority, though the writ petition said that there was no conversion in favor of the private respondent, and how private respondent's name did appear in the record of rights, they were not aware. Thereafter conversion, thereafter without plan, they were constructing on that particular land of 19 decibels. Writ court has found, after hearing my learned friend, that there was a conversion, a valid conversion in favor of them, a valid sanction plan in favor of them, and writ court has said that if you want to agitate the title issue, the best forum would be the civil court. Go before the civil court. Thereafter, they challenged that particular order before the division bench. Honorable division bench has held also in the same way, and now they are trying in the garb of trying to change the record of rights as if their name was up in the RSROR, in the mother copy, thereafter finally attested copy, but in LR mother copy, but in the LR copy, their name is not appearing. As if like that. But
So, Mr.
Well,
Samad, what is your problem? The appeal court gave you liberty to go to the panchayat.
Appeal, I moved this application before the read court that some persons, that is the private respondent, forcibly constructed a house. I have not a copy, even if and they have disclosed it, they have named.
So that writ petition was dismissed.
Dismissed, but I have not challenged only for came before you for illegal construction. And liberty was given by the appeal court. If it is Panchayat authority sanctioned the plan, you made objection. Thereafter, I learned
nothing has been filed.
Thereafter, let me submit. Thereafter, I learned that name was recorded. I am originally, my lord, for a moment, I am telling. Originally, Kanailal Bera, the grandfather, he is the recorded owner in RS plot number 4049, LR plot number 4745, that is a respect of Jol, 19 decibels. And he died leaving behind 3 sons, Punno Bera, Anil Bera, and Lakshmikanto Bera. Petitioner here in Punno Bera, so legal years of Punno Bera and legal years of Anil Bera. According to Hindu Succession Act, we are entitled 1/3 share. On that basis, the up to attestation, my name was recorded. That will be see for a moment. Up to in the year 1995 and 1996. I have annexed those attested copy. Page 48. Page 46. Start from page 46.
Where is your original application? Have you annexed
Original
that?
application I have annexed. That is page 35. That is the land tribunal application. In this application, I have annexed the record of rights up to attestation 46 and 48. It will be reflected. 46, page 47. That is plot number 4755. My lord also got it.
জজ সাহেবদের আগের দিন যে আমি ইনস্ট্রাকশন দিলাম সেটা ফাইলে নেই।
Come to page 31.
31.
In the writ petition, you claim to be the owner.
Yes.
So what is the finding returned by the writ court? Page 31.
Well, page
With
31,
regard to the
page
with
31.
Second paragraph.
Second paragraph. That application was moved. Some person illegally constructed a house. That is not for correction on the record of rights.
Illegally constructed on the strength of your submission, that is bad. You are said you claim to be the owner.
Yes.
So your name was recorded up to the attestation stage.
Yes, up to attestation.
Now ultimately the court disbelieved your contention and
my lord,
said
I
that if you have any
I have annexed those documents.
We are not going to go through that, Mr. Samad. Let us come to the writ court order.
Yes, yes.
So your claim for title, was relegated to the appropriate authority. Writ court making an observation.
That is my case, my lord, without service.
Now, if you want it to be considered by the BLRO, what he will say? Can he go above the order of the High Court?
No, the High Court had not decided the title.
Yes, it cannot decide. That is why the observation, page 31.
Yes, page 31, I am.
With regard to the claim for title, it is submitted by reason that one of the petitioner was a witness to the sale deed by which the petitioner transferred. However, in any event, the questions of writer cannot be adjudicated by the writ court. So there is a specific finding as regards your claim towards title. So after this observation, can the BLRO record your name? Tell us.
My lord, well, I am submitting, my lord.
No, Mr. Samad, please answer our query.
Yes, yes.
After this observation, which was carried in appeal and appeal was dismissed, can the BLRO consider it at all?
My lord, my lord.
So it is better you wait for your turn to establish maintainability before the tribunal. Tribunal has dismissed it. Tribunal has not dismissed it. Try your luck before the tribunal. And if you want us to go into it, we will make this observation, which will become more difficult for you. এই বুঝতে পেরেছি
Yes.
তাহলে শুধু শুধু করছেন কেন?
I follow it. In the tribunal, but my preliminary.
Tribunal has not yet dismissed your OA.
Yes.
Tribunal has said that it appears it is not maintainable. However, we are keeping it on that date. That is the strength of the order. To try your luck before the tribunal, why you are coming to us? So you withdraw and you pray for preponement of the hearing before the tribunal.
Milord, may I?
The prayer of Mr. Samad, learned advocate.
May I submit one thing, Milord?
Ar ki ache?
One thing.
He is withdrawing, sir. Mr. Samad, learned advocate, appearing for the petitioners, prays for leave to on the prayer of Mr. Samad, learned advocate, appearing for the petitioners, comma, the writ petition is dismissed as withdrawn with liberty to prefer an application for preponement of hearing of the application, preponement of hearing before the learned tribunal. Yes, next. ওই রিপোর্টটা ওনাকে ফেরত দিয়ে দাও ধর তাই তো ইয়েস
Well, in this matter.
I appear for the status. Nodi.
Yes.
Nodi.
But it is not Nodi. Yes, I will submit, my lord. Yours kindly. Before going to the records, my lord, yours kindly. I have come, my lord, against the refusal for passing the interim order.
Yes.
The land which is not under the disposal of the government, but over the land, the state authority want to install the, my lord, the solid waste, my lord, the management. That is why the notice has been issued. Assailing that, my lord, I move the move the original application before the tribunal. In connection with this original application, an interlocutory application for interim order was filed, and the report was submitted by the authority. There, the point, my lord, the raised that the land is not at all vested to the state government, and the tribunal was in confusion by saying that in which act the land has been vested to the state, whether 44(2)(a or 6(1) or 14(t)(3). That is why the report has been called for. একটা পর একটা দেবে তাহলে
ভুলে গেছি এখন এসে একজন নিয়ে নিল Mr. Sahu, you took
Yes.
adjournment. We have forgotten again.
No, I'm telling, my lord. Very
You
short.
are telling. Now you will 1 hour, you will argue again. We have to listen.
No, I will
At
not.
your instance, we fix the matter.
Yes.
And on that day, that unless you give us an interim protection, holidays are coming, we will be thrown out. You did not appear. Your friend said, all right, keep it after the vacation. So now you are again coming, you will again argue for one hour.
Not 1 hour. I will take, my lord, 5 or 10 minutes.
Day after tomorrow. এই ফাইলটা একটু আমাকে পাঠিয়ে দিও
Tomorrow.
Day after tomorrow.
Well, day after tomorrow, 20th. My lord, I have got one matter is fixed in another forum.
My brother won't be here for 2 weeks. So choice is yours. If you don't want day after tomorrow, it will go to 9th December. If you want to come, we come. We have no problem. 10th December, dear thou. Yes, next.
Well, tomorrow it will be. Well, your lordship, kindly take it up tomorrow.
10th December, let my brother come back. We will consider. Yes, next matter, Doctor.
21 তারিখ
9.
বুধবার পুলিশের একটা ফাইল নিয়ে পড়া। হ্যাঁ ঠিক আছে তাই
তুমি তো 9 তারিখ ফিরে আসো
10 ডিসেম্বর ঠিক আছে।
Who is for the petitioner? Devobroto Rai. Where is he? Mr. Galib, you are Mr. Sahu again appearing in this?
No, no.
এটাতেও আছেন?
না বেশি ম্যাটার নেই
নেই? Yes. Yes, Mr. Galib, you are
Lordship.
all right now.
Lordship, gradually recovering, Lord.
Who is your other side?
Mr. Rai Mr. Rai was
কে
there.
গো?
Mr. Rai.
কে appear করেছিল?
9.
Item number 9.
Mr. Rai was.
Where is Mr. Rai?
My lord, Mr. Roy is appearing in courtroom number 29, my lord. We are praying for short Passover, my lord.
Not today.
Not sure.
It is for hearing. Affidavits have been completed.
A report on affidavit, Lordship.
Uh-huh.
Report on affidavit, AOAR, yes, have been completed.
That has been completed. So
Lordship.
it has to be finally heard.
Yes, my lord.
Lordship.
Then you come on 10th December. 11th December পড়ে দাও. Yes, next part heard.
Lordship.
My lord, I am appearing for the
Yes,
response.
where were you on the
My
last?
lord, I apologize, my lord. I actually missed that part where your lordship made it parted, and I was searching in code number 4.
Then we will release the part.
No, no, my lord.
Your searching won't be in vain.
My lord is I have here heard the matter extensively, my lord.
Heard extensive. জামা এসছে promotion আর How long will you take? বেশি নেবে না?
No.
Yes, tell us.
My lord, we have challenged the order dated 6 October 2016, my lord, passed by the tribunal in, my lord, application number 525 of 2015.
Uh-huh.
My lord, we have challenged the order.
When did we last hear you?
Last year, lordship heard me, my lord. 7th October, my lord. Thereafter, the matter was appeared last week, but my understanding was not that the matter was adjourned, my lord. Before vacation, your lordship heard it on 7th October, my lord. Initially 24th September 24, 24th September. 24th September, your lordship heard it, my lord.
219. All right, tell us what it is.
My lord, 6th October, my lord, I tell the facts of the matter, my lord. The petitioner was appointed as, my lord, helper A under the scientific and technical rules, my lord.
No, you first place the order impugned, then you can go to the facts.
Then, my lord, kindly come to, my lord. The order impugned, my lord, at page, my lord, 76, my lord.
Page 76.
Immediate after 76, my lord.
একটা লিস্ট অফ ডেটস দিয়েছে তো দেখছি।
Yes, my lord.
সাপ্লিমেন্টারি পিটিশনের থেকে বড় করেছে।
But supplementary also some my lord.
They have given this.
My lord, supplementary we have included the why it is voluminous.
When did they engage you?
Supplementary included.
After engagement, you took steps for supplementary.
Well, supplementary including my lord, way, original application, then reply, then rejoinder. That was not initially with the writ petition. That's why we have compelled to file this, my lord.
Achha, where is the order in
order page, my lord, writ petition, my lord.
After page 76.
76, my lord. Kindly come, my lord.
Then what is page 75?
75, my lord.
Ajoy Dhar, there was another order on 27.
This is a miscellaneous.
MA disposed of.
This is a miscellaneous application, my lord.
One MA was filed.
That was, my lord, pertaining to something else than that of this, my lord, writ petition. If your lord kindly straightway come to this order impugned, my lord, 6 October 2016. May I place in, my lord?
Yes.
The applicant sought for the following reliefs. The reliefs was there, my lord. Order to issue directing the respondent authorities to immediately grant all arrear promotions due to the applicant as specified in paragraph 6 of the instrument application with proper refixation of his pay and allowances as well as designation. An order to issue declaring that the applicant belongs to scientific and technical cadre, quashing thereby any order, memorandum, decision, etc. arrived at by the respondent authority which declare the applicant belongs to non-scientific and technical cadre. An order to issue directing the respondent authorities to immediately release the arrear of pay and allowances of the applicant commensurating with all his dues, legitimate past promotion, any other like for the order. Then the applicant who was initially inducted in service as casual labor was regularized on the post of helper A by an order dated 16 November 1992. Thereafter, he was promoted to helper B on 12 November 1996. He challenged his regularization with effect from 1992 on the ground that his period spent as casual labor should also be included, but the relief has been declined in the way filed by the applicant before the tribunal in way number 514/2000, against which a writ petition was filed, but the same was also dismissed. That he filed another way, but the same was dismissed. The order was challenged before the Honorable High Court in such and such. The AST was decided on such and such with liberty to the applicant to make a representation before the authority ventilating his grievances, and the authorities were directed to dispose of the same within a stipulated period without making any comment on the merits of the case. In pursuance thereof, the applicant preferred a representation which was disposed of by the order dated 27th January 2007 by the respondent authority on 9th March 2006. The respondent order was challenged before the Honorable High Court in WPCD number such and such, and the same was also dismissed.
Is that AST 117 of 2005? This was a fresh writ petition or the earlier writ petition continuation?
No, this is fresh writ petition.
Challenging that order, how can you come to fresh writ petition?
No, my lord, what happened?
9th of March 2006 was the order passed in terms of the earlier writ petition order of 7 July. Previous page, filed OA 174, dismiss, order was challenged by High Court in AST 117 of 2005.
Yes.
Wherein liberty was granted to you to give a representation and for them to consider.
Hello.
They did it on 9th March 2006. Then how can you challenge that order before writ court? You have to go to the tribunal.
My lord, thereafter again I went to the tribunal.
Challenging that order of 9th March.
List of dates. Well, kindly take some my list of dates, my lord. It will help, my lord, I think.
Ninth March.
My lord, kindly come to page 2.
AST 117, what is the WPST number?
My lord, WPCT, that was, my lord, 514.
514. So that was disposed of 9th March. Then,
my lord, 2007.
Challenging the order passed in OA 174 of
2007 was dismissed. Again, my lord, I filed, my lord, OA. Then, my lord, it was challenged in 124 WPCT. And if High Court was pleased to grant order of status quo. Then, my lord, 124 was dismissed. Then, my lord, we filed a review application. In that review, my lord, that was disposed of, clarifying that respondents are free to decide the issue of promotion.
Have you retired now?
Yes.
When did you retire?
31st October 2024.
31st October
2024.
So at the time of pendency of this writ petition.
My lord.
During this writ petition pendency,
I retired.
Yes, come to the order now.
Well,
Paragraph 4.
Paragraph 4. The aforesaid order was challenged before the Honorable High Court in WPCT 124/2009. The same was also dismissed by Order such and such. He also filed a review application, which was also dismissed on 12 September 2012. It is a fact that a restructuring policy introduced with the approval of the Government of India Ministry of Information Technology Director, which has been brought on record by the respondent along with his reply. This review application, my lord, it was, my lord, 12 September 2012. It was ultimately disposed of, not dismissed, with a observation of the Honorable Court, my lord, that the department is free to decide the issue of promotion. The tribunal, my lord, recording, my lord, it was wrongly
Now,
recorded.
thereafter, it was disposed of by the department. This liberty, this observation, after this observation of the review court, any order was passed by the authorities.
My lord,
where is the review petition order?
Well, review petition order, your lordship, find, my lord.
বুঝতে পারছি
Page 60, my lord.
Page 60.
Page 60.
আচ্ছা, page review was of 2011.
Kindly come to page 63 straight away, my lord.
So this was on 12th of September 2012.
2012.
Then what happened?
Then, my lord, kindly come to page 63. The observation of the
it was left. Now the authority would be free to decide the promotional avenue.
My lord.
Decision of this will have. Now what happened? Thereafter, any order was passed?
My lord, thereafter, my lord, no order was passed by them, my lord. With my wife, my lord, filed a RTI application. My wife filed an RTI application because authority concerned regarding the, my lord, promotion rules regarding promotion, my lord. And, my lord, it was ultimately
Your
said.
wife, why you are Ajay Dhar?
Yes.
Your wife filed RTI?
My lord.
You know? Ajay Dhar was.
Ajay Dhar also subsequently, my wife also initially filed an RTI application there, my lord.
And page 77.
Regarding, my lord, restructuring, they are asking as if I was not a non-technical, I was not another technical.
ইয়ে আছে নাকি গো? Stapler আছে নাকি গো? Stapler আছে, stapler? স্টেপল করে দিন। দিন আমার।
ওদেরকে বলো না, তুমি প্রেজেন্টেশন করলে করলেন, ওইটা বলো। ওইটা দেখো প্রেজেন্টেশন করলে না।
এটা করেছি এই যে দেখুন না, অফিস অর্ডার করছে।
না না, ওই মিশের পরে।
না, তারপর তো ওখানে চলে যাচ্ছে।
Yes, Mr. Bhattacharya.
My lord, then, my lord.
Where is the RTI দেখি না?
My lord, RTI, your lordship, find, my lord.
RTI was filed.
Yes.
Now in RTI, what did they reply?
Well, they reply, my lord.
77 of supplementary.
Page 58, my lord, kindly come, my lord.
58 of what?
58. Writ petition, my lord.
Writ petition, page 58.
My lord,
so you have given page 77 of supplementary affidavit?
Well, there also supplementary, my lord, that is included the original way. Way had everything is there in the way, my lord. If your lordship can take up, then, my lord, I will place the, my lord, the way.
77.
77, my lord.
কত ডেট? 21/12/2000। কোথায় দিয়েছে সেটা? পেজ কত?
58. So they are saying helper A and B are governed by wise policy of 1983.
83. That was the DT's policy
not
by which
recruitment rules.
Not by the recruitment rules. Remember that means, my lord, and that means to say, my lord, I have been appointed on the scientific and technical trade, which is the DT's policies. They have replied the RTI that my service rules, my promotion is guided by the DT's rules of 1983. That is, my lords, appointment of scientific and technical trade cadre. Well, if your lords kindly takes up, my lord, at page
Page 750 cadre structure of non-SNT is under process. So, of structure.
my lord, kindly come to page 75 first, my lord.
You finish the order impugned. You are reading page 3.
Page 3, my lord. Then, my lord, the another notification, 12th March 2001. This is the date is very important, my lord. 12th March 2001, one notification came, my lord. What in the notification there? Kindly cease, my lord. Kindly turn the page. Kindly come to page 4. Restructuring of non-S&T cadre in STQC labs regarding rationalization of designation of Group D employees and implementation.
Written on page 4 of the
Yes.
During analysis of reports after visit of Manpower Review Committee, it has come to notice that STQC headquarters that there are total 5 Group D employees, helper B3 and helper A2, working in technical laboratories and accounted wrongly under S&T category by labs. Now all these 5 persons are being correctly accounted by STQ headquarters under non-S&T staff as they are support staff under Group D category. ETDC Bangalore has correctly shown 1 helper under non-ST category as per recommendation of Manpower Review Committee. Peon/helper/B Group D staff are recommended to be utilized in any area of lab, whether technical or non-technical, to enhance their utilization and are shown under non and ST category only. Presently, there are 8% working as Group D, including helper B in the pay scale such and such as mentioned below. As there is no sanction post in the pay scale of such and such after cadre structuring of non-ST staff, competent authority has approved that the designation of these persons should now be changed to Group D cadre 1 and give pay scale of such and such as personal to them against sanction post of Group D cadre. That is, when these persons resign or retire in future, post will automatically fall vacant in pay scale of such and such. In view of above, competent authorities have approved that ERTL, ETDC Bangalore, Mohali and ETDC Jaipur may make corrections as shown below accordingly in their manpower database and in their service and personal records of individual concerned by changing designation of helper A, helper B, helper 2, Group D cadre 1 and shown under non and ST category instead of presently under technical category under confirmation of STQ headquarters. Then, my lord, kindly see the chart has been given. Present designation and category Group D, Group 1, sweeper, non-ST. Then, my lord, kindly turn the page. Ultimately, that was this shown in serial number 7, my lord. Ajoy Kumar Dhar shown it helper B, S and T. They themselves shown, my lord, what they have shown, present designation category. My lord, Ajoy Kumar Dhar, kindly come to the page 6, bottom. Serial number 7, Ajoy Kumar Dhar, helper B, S&T, scientific and technical cadre. And my lord, he was promoted to from helper A to helper B. Then, my lord, this is issued as per approval of competent authority. The perusal of this restructuring policy makes it clear that all the 5 helper working in different stations and also STQ headquarters, irrespective of the fact whether they are working in in lab or offices, were declared as non-ST staff and categorized as such. The order was also passed in pursuant of the same, and at serial number 7, the applicant was designated as helper B category, as SNT earlier was revised, designated as Group D, Group 1, personal to him non-ST. Now, in present way, the applicant claimed the benefit of promotion on the basis of the fact that he belongs to SNT category, as he is working in environment laboratory as helper B to assist the technical officers, and as such he is performing a technical job, and he must have been designated in SNT category, and on the basis thereof he wants promotion to scientific assistant A from the year 2001 in terms of the policy. Therefore, a short question of considering before this tribunal is that whether the applicant belongs to SNT category or non-SNT category. The applicant claims the category of SNT on the basis of job he is performing at present. The letter dated 12 March 2001 referred herein above makes it abundantly clear that all the 5 Group B employees, helper B, who were earlier designated wrongly by different labs, were now correctly put by STQC headquarters under non-ST staff. He was appointed as such in pursuance of this order in the year 2001. The order has not been challenged by the applicant in this original application. A relief has been claimed that whether order whenever passed should be set aside, whether the applicant has been declared non-ST staff. It is noticed that the order passed in 12 March 2001, he did not challenge the order specifically, probably for the delay in preparing the application. As in view of the restructure of the mistake was correct, and all the 5 Group B employees working as helper B in different laboratories and in headquarters were designated non-ST staff. Hence, we are of the view that presently applicants should be treated as non-ST category. The order which was attained finality after lapse of time, wherein he was designated as non-ST category, the challenge cannot sustainable. Accordingly, the relief which the applicant has claimed in the way cannot be allowed. There is one more important fact of the notice, that in 2007, selection process was initiated for promotion to the post of assistant A, but the applicant has not participated in that selection, claiming himself to be in category SNT, and in the way he claims that he is not supposed to undergo a trade test of typing, which was an essential requirement for promotion to assistant A. Now, my lord, kindly takes up the original application, my lord. My lord, relevant facts are necessary to be placed before lordship. My lord, if your kindly takes up the supplementary affidavit annexing the original application.
No, Mr. Bhattacharya, you were incorporated in the category of non-ST category in terms of the restructuring way back in 2001. Admittedly, you did not challenge the same.
No, I have, my lord, made time and again the representation challenging these things. They ask me to adopt the
2001 it was done. Your 2001, this order which you are impugning is of 2016.
Hello.
So 2001, the original application, that was not under challenge. 2000, you cannot come out of the regards of this statement that 2001 restructuring was not challenged by you.
My lord, regarding restructuring,
After obtaining RTI, you got some other idea and you filed the application after 15 years.
No, my lord. Right from, my lord, 1996, I am asking for my promotion. Kindly appreciate, my lord. I was appointed in 1982.
That chapter is over. That has merged ultimately into the granted review petition, which said that it will be open for them to consider.
My lord.
That does not create any right in your favor.
No, but at least my...
After that, when was that order passed? That review petition order was passed in 2012.
Yes.
That is 11 years after restructuring.
No,
2001 was the restructuring.
My lord, regarding restructuring, my lord, the authority give me the answer when I put the RTI. My lord, it has not been approved as yet. It is simply a letter given by the department. It was never been, my lord,
What they will approve? If you are non-ST, you are not entitled to the promotions which you are claiming.
My lord, regarding restructuring policy, my lord, that has not been confirmed, that has not been given effect to as yet. That I show to your lordship from the original application, that has not been given effect to at all. And one thing more, kindly appreciate, my lord, regarding the policy for appointment of, my lord, Group A helper and promotion to the Group B helper, that rules has not been, my lord, superseded by this policy. Had that been the case, my lord, this policy or this letter superseded my appointment by which I was appointed, my lord, then could have there is a case of the government, my lord. Kindly appreciate, I appointed by the DT's policy. That policy still remain. I have annexed one document with this, my lord, supplementary showing, my lord, they say that this post automatically it has been stopped, but they again notify for.
That is why you did not challenge the same.
No, I have.
Your contention is when I was absorbed,
my lord,
I was in terms of the diet SQ that policy.
My lord.
Now after absorption, that was after absorption, when did you repeatedly approach the tribunal saying that give me the promotional benefits, etc.?
Well, first I asked for regulation. Then I was
no that dispute was settled by the final order passed in the WPCT.
Yes.
Thereafter, you filed a review.
Yes.
Review kept a window open that what is the window today after disposal of this writ petition? The authority is free to decide his promotional avenue.
My lord.
So authorities, what they are saying? They are saying that promotional issue of 2001, that avenue in respect of the 2001 restructuring, no further promotion is available. That order is not under challenge.
My lord, that order, though not specifically challenge that way.
Then Mr. No, if you do not challenge a particular order, because this order of review was of the year 2012. You filed the original application after 6 years, 2016. You did not specify also what is your prayer in the original application. Give me promotion.
Kindly see, my lord, in the prayer, my lord.
Prayer is give me promotion.
Prayer B.
Prayer B, kindly see, my lord.
Yes.
I have
So if it is not implemented, why you are seeking such declaration?
Yes.
Prayer B.
My lord, prayer B, I have asking why.
No, read prayer B.
An order to issue declaring that the applicant belongs to scientific and technical cadre, quashing thereby any order, memorandum, decision, etc., arrived at by the responding authority which declared the applicant belong to non-scientific and technical cadre. And then tribunal says that we have not challenged. Specifically, the prayer is there. It has been challenged. It has not been considered by the authority.
Mr. Bhattacharya, what you have said? After this is of 2016, that is after 15 years, you are saying that you quash whatever order that has been passed.
My lord, all throughout, right from my lord, original application, my lord, I have made representation to them and filed the original application asking for promotion on the basis of my recruitment rules. Kindly appreciate, my lord. Let them show that has been given effect to. I will show from the RTI answer given by the authority that this 2001 letter has not yet been, my lord, approved by the government.
That was not your case before the tribunal, Mr. Bhattacharya.
Yes. Well, way I have gallowed the representation is my kindly state.
Show us one line that you have made the statement 2001 restructuring was never given effect to. Show us that line.
Page 15.
Page 15.
আমিও জানি।
Page 3 of the order in queue.
My lord, kindly come to my lord.
Page 3 of the order, it is a fact that the restructuring policy was introduced with the approval of Government of India, Ministry of Information and Technology in such and such.
It is the order.
That means introduced with the approval of the government.
My lord, it is the order of the my lord, tribunal.
Tribunal.
Tribunal said.
Of the time.
Tribunal said, my lord. Now, my lord, kindly seize, my lord. What I have stated in my original application, kindly take some, my lord. What is the pleading there, my lord? May I place it, my lord? It is very relevant to place it, my lord. Otherwise, my lord, I could not make myself understand, my lord. If your lord say, kindly come to page 9, my lord, of my page 10, rather, my lord, of my original application. My lord, supplementary affidavit, my lord, kindly come to page 10.
Okay, we are coming. Oh, supplementary.
My lord, my lord.
সাপ্লিমেন্টারিটা কোথায়? এই যে
Yes, please. 10. 1 minute.
yes.
Yes, question.
My lord, kindly come to my lord. My lord, kindly come to page, my lord, 11.
Yes.
My lord, Roman 5, my lord. Your applicant states that after joining the service, he subsequently upgraded his qualification and obtained the diploma in electrical engineer with first class in 2001 with prior permission of the employer. Your applicant states that the respondent authorities were duty bound to take into consideration the higher qualification obtained by the applicant and should have allowed all the consequential service benefit to that effect, including promotion. It is being further stated by your applicant that he also had science discipline in intermediate. Then, my lord, the petitioner states that he was promoted to the post of helper B from helper A.
That has no connection, Mr. Bhatt.
Connection is there, my lord. 2001, kindly appreciate, my lord. 83, I was 92, I was, my lord, regularized. 96, I got the promotion. Then immediate 3 years, my lord,
You enhanced your qualification.
no. I entitled to get promotion in 99. Then, my lord, 2001, I entitled to my promotion as I have got the.
That is why in the reply, they enclose that. In the reply to the AO, you will find their communication 9th of March 2006. Come to that memo of 9th of March 2006. In the reply, they have recorded that.
My lord, their rejoinder, my lord, page 129.
Page 197 of your supplementary affidavit. This is after the review liberty. No, sorry. This is in the original application.
My lord, original application, their reply, my lord, starts at page 80. And my lord,
order is at 9th March 2006, page 97.
এটা আমি চ্যালেঞ্জ করলাম কিনা
এটা পরেই তো ফাইল করলাম
হ্যাঁ
2006 এ পরে
You were regularized when, Mr. You
92
174
You are saying 1994?
no 1992 I regularized as helper A then 96 my lord I was
you got the
promoted to
promotion.
helper B
Now
then my avenue to promotion due on 1999
no. Let us understand. 92 you were regularized.
My lord.
96 you were promoted.
My lord.
After that you made an application for retrospective regularization.
no initially before I regulation well I made representation that I should be
Forget
because
it.
I was appointed in 19
Just understand, na?
My
You
lord.
were regularized in that post of helper A in 1996.
no 1992
Helper B in 96.
96
Thereafter, you approach the tribunal seeking retrospective operation of the regularization. That give me from the date I was working.
my lord
That was ultimately rejected.
my lord
Challenging which you preferred, but court did not allow. But you filed a review petition, saying that in the review petition, court says that that promotional avenue has not been considered by them.
because why my lord because my lord I'm pausing here for a moment because I made by that time my lord, I made several representation asking them give me promotion my promotion is due from 1999 onwards please give me the promotion I got the extra qualification please give me the promotion they did not do it they
Then
what
ultimately, after the review court order,
my lord
they passed an order. Where is that order? After the review, liberty given. After the
well,
review,
after review I made representation they didn't pass any order my lord
so that was 2016. Review petition was disposed of on 2012. I think.
12
Huh? Review the 2012.
and my lord from 2012 onwards
Now, let us understand, now, Mr. Bhattacharya. Kindly come to the review order that is at page 63. Please read page 63.
authority waited for a decision that was an administrative wisdom. Today, after issue of this lease before this court, the authority is free to decide his promotion
Read
avenue.
from the beginning. The issue in the tribunal application would relate to reciprocal benefit of regularization.
My lord.
Neither the tribunal nor this court considered the issue of promotion.
My lord.
Now it is open. Window ta opened.
My lord.
If the authority waited for a decision that was an administrative wisdom.
My lord.
Today, after disposal of the lease, before this, the authority is free to decide the promotional avenue in accordance with service rules. Now, after this, which order was passed by them?
No
order was passed.
No.
You made RTI application.
No, I made representation time and again.
Show us which representation
From
you made.
2001, my lord. My lord, kindly come to my lord.
After the order in review, which representation you made? After 2012?
2012.
That is page 74 of the supplementary evidence. Let us see page 70. '74 of the supplementary.
44, 40, 43 onwards. 42 onwards.
My lord, 42 onwards, kindly see my lord.
No, 74.
Oh.
This is your representation. In your list of dates, you have stated that. Across in
My lord, 12th October 2012, page 62.
Page 62.
62. October 2012, my lord. Review that was kindly takes up page 62 of the supplementary review, my lord. Page 62 of the supplementary review.
Page 62, yes.
62. In continuation of my previous correspondences, in respect of the denial of promotion to me on the pretext of the dismissal of my appeal before the Honorable High Court WCT 124/2009, I again raise this issue with request to grant me relief in accordance with law. Further to the same, I place on record that I had to file a review application in the aforesaid matter to substantiate before the Honorable High Court, Calcutta, that the subject matter of challenge had never been with regard to the denial of promotional avenues. I do not know as to why this persistent attitude to harass me has been taken by the department, though throughout my career there has never been an occasion that fault in my work could be found out by my superiors. Be that as it may, the Honorable High Court in my review application under reference such and such has already held on such and such inter alia that promotion had never been the subject matter of challenge before the Honorable High Court. A perusal of Solomon order passed will substantiate the same. In such circumstances, I reiterate all that I have previously corresponded and also the contents as stated herein above. I thus request you to immediately provide me with promotional avenues as to enable me to achieve my career advancement in accordance to STQC policy such and such 1983, by virtue of which I was regularized in the scientific and technical SNT post helper A in 1992, and after that promotional to the post helper B in 1996. Then, my lord, next page is very important. Kindly take up page 64.
Your representation regarding.
My lord, kindly see, this was Arvind Kumar, Senior Director of the Scientific and Technical Department, my lord, written to me.
Under processing.
Is under process. It is under process. Act. The tribunal. As per personal administration oil, after finalization of the cadre, you will be considered for promotion if eligible as per recruitments. Till then, as far as STQC is
under process in consultation with the Ministry of Finance even in 2013. Restructuring question does not arise, my lord, because it is there later. They admitted it is under process with the Ministry of Finance. Then, my lord, kindly turn the next page. This is my representation again. This was given in 31st December 2013. Then, my lord, kindly turn to my lord 67, my lord, 4th January 2013. My lord, if I place in the last paragraph, my lord, of first page 67, what I am entitled to, my lord, I would like to bring to your kind notice that the following promotions could have been effected in respect of my service career, since there had been no occasion to deny such promotions or withhold the same. In the year 1999, I was eligible for the promotion for the post of tradesman B. It is extremely important and pertinent to mention here that I was denied the promotion to the rank of tradesman C or to the post of scientific assistant A in the year 2002, particularly when I completed my diploma in electrical engineer with the first class in 2001. In the year 2005, I have been denied the promotion to the rank of scientific assistant B. Further, in 2008, I have been denied promotion to the rank of scientific officer engineer B. Then presently in 2011, I am eligible to the rank of scientific officer engineer C, and 2014, I shall be eligible to the rank of scientific officer engineer D. Although I have been told to opt the MSCP, that is important, I didn't opt it, my lord, rather I deny it scheme. But in my humble submission, such MSCP scheme cannot be applicable in my case, especially when I have been the avenue for promotion in the particular cadre. Therefore, there was no occasion to opt for such MSCP scheme as and when I was informed to avail the same. Your good office should also appreciate the MSCP scheme, if at all, would have been made applicable in respect of my service career. There cannot be any justification to offer such scheme to me and to let your office know as to whether I am interested to accept such offer. Instead, the benefits provided in the said scheme would have been directly awarded to me without being any question to offer or question offer and acceptance. Therefore, it is clearly shows that such offer was given to me with a malintention to deprive me of my promotional avenues. Therefore, under the facts and circumstances indicated above, I would request you to look into the matter and accord all my due promotions to enable me to avail all the due consequential benefits. Then, my lord,
Representation position October.
then my lord, next, my lord, page 71. Again, I, my lord, give my representation, my lord. Then, my lord, 4th June 2014, same. Then, my lord, 15th July 2014, again, I have reiterated my promotional avenue for a promotional avenue, my lord. Then, my lord, the RTI. My lord, this is very important, page 77. Well, first RTI, that was your lordship fine, my lord. RTI given by Papia Dhar. Well, answer given by the authority.
After page 64. 64 under process.
My lord, page 77, kindly sees, my lord.
Where is that reference to manpower committee?
Manpower committee. Review of manpower committee. Manpower committee. কিন্তু ওটা বেশি, এটা আমাদের order আছে।
But in 2001, they referring that STQ thing, which I have, my wife put a ITI, answer given in page 77, kindly sees, my lord.
Page 77.
My lord.
Supplementary. Supplement.
First paragraph, last line. Or first paragraph here, I read, my lord. This is with reference to the communication of such and such office RTI STQ department forwarding here with the appeal of Srimati Papia Dhar, wife of C. A.K. Dhar. From the records as available, the desired information is enclosed. As regards the approval letter of DOPT on information of Manpower Review Committee, it is informed that no material information is available with STQ department. Then, my lord, kindly turn the next page. Next page, my lord, 78, kindly last two lines, my lord. Name of complainant, Ajay Kumar Dhar, my lord, right hand, left hand top, bottom, my lord, left hand top. Then, my lord, top, your lord, kindly see status as on 30th May 2014. My status of service, my lord. Status as on 30th May 2014, my last two lines, my lord. Cadre restructure of non-ST is under process after finalization. He may be considered for promotion if eligible as per recruitment rules. Then, my lord,
তারপরে আমার
page 86. এবারে page 80 last paragraph.
আমি চাইলাম যে হেল্পার এ এন্ড বি রিক্রুটমেন্ট রুলস দাও, তাতে ওরা রিপ্লাই করে আমাকে বললো ইন দিস রিগার্ড স্টেটেড দ্যাট বিলো গ্রুপ এ এন্ড এসএনটি অফ দ্য ইনক্লুডিং হেল্পার গভর্ন বাই 1983 policy.
বলছে ম্যান পাওয়ার
policy.
My lord, then my lord kindly take some, my lord,
এটা কিন্তু
page
এখানে
57 of the writ petition.
ওরা বললো it is under এখানেও বলছে রিস্ট্রাকচারিং ইজ আন্ডার প্রসেস। রিস্ট্রাকচারিংটা আলটিমেটলি এফেক্ট দিয়ে দিয়েছে ওরা 2001 থেকে, মানে আফটার হি গট পারমিশন টু দোজ পোস্ট।
এইখানে অন্য কথা
সেটা তো রেট্রোস্পেক্টিভ প্রমোশন, সেটাও ঠিক আছে, রেট্রোস্পেক্টিভ রেগুলারাইজ।
My lord, STQ is Standardization, Testing and Quality Certification Directorate. That the notification of 2001.
এক্স্যাক্টলি, এবং পার্সোনাল বিলেন করে ওদের পরে আর কন্টিনিউশন ইট উইল ডাই। এখন এই 2001-এর রিস্ট্রাকচারিং এর গল্পটা ওরা ট্যালি করছে না। রিপ্লাইতে বলছে 2001-এ ম্যান পাওয়ার কমিটি করেছে, কিন্তু ওদের আরটিআই এর রিপ্লাই ওরা বলছে এখনো যে এই ফাইন্ডিং অফ দি ট্রাইব্যুনাল দ্যাট হি হ্যাজ নট চ্যালেঞ্জড।
This, my lord, service rules. If your lord's can takes up page 57 and accept P5. There, my lord, I requested them to provide me the recruitment rules of my appointment. My lord, kindly take some, my lord, page 62, my lord, page 57 in 2015. In 2015, kindly, my lord, write on top, my lord, 12th November 2015. I wrote this letter to Mr. V.K. Chandra, Central CPIO, regarding, my lord, attested copy of recruitment rules, helper A and helper B, laboratory assistant copy of group D, etc., etc. Then, my lord, kindly turn the page, my lord, kindly come to next page, my lord. In 21st December 2015, what they have stated, second paragraph, my lord. In this regard, it is stated that below group A, S&T officials, including helper A and B, are governed by the DT's policy of 1983 and amended from time to time, not by the recruitment rules. Therefore, even 2015, my lord, I was guided by these DT's rules, this 1983 rule by which I was absorbed, I was, my lord, regularized, I was promoted from A to B, helper A to B. That is, my lord, scientific and technical cadre. And my lord, the STQ is there. STQ, my lord, which they have said that it has yet to be finalized. Kindly, I have shown the RTA, my lord. My lord, STQ denotes, my lord, it was, my lord, Standardization, Testing and Quality Certification Directorate. My lord, tribunal did not consider all this aspect given by the authority himself that it is under the consideration of the Ministry of Finance. It has not been, my lord, approved. It is under process, my lord. And right from 2001 onwards, my lord, I am making my representation galore. They didn't consider it. One fine morning said, no, this is the network, get out, you. I rendered my services, they got all my things from me.
Don't go so far, sir. Your matter has been repeatedly not found to be suitable by the different coordinate benches. So don't go so far. Only this point you are arguing, that if it had not been finalized, how you can come to a finding that I have not challenged the 2001 restructuring. That is your only point that we will ask from you.
My lord. Now, my lord, one thing more, my lord. Tribunal, in fact, my lord, these documents I am I am showing to your lordship, my lord, from the original application itself. Tribunal didn't consider all these aspects there, my lord.
No, why they will consider? Because your case was only of regularization initially. Your initial claim, which was running, that was of regularization. After regularization was given, you said, give me retrospective regularization. When that was rejected, you took a new plea that I am not under the restructuring cadre policy of 2001. I am not a non-S&T cadre. I have to be granted the consequential promotion after the helper B post. This is a new prayer you are making on the basis of what? Yes, Mr. What do you say, Mr.
My lord, kindly, for the last 30 years, I am working.
Tribunal order.
My lord, kindly appreciate one thing.
Just. The page internal page 5. Top paragraph. Competent and designation new will be personal.
Well, for the last 30 years, I have discharged my duty as Group B helper here, my lord. In 99 and 2001, my lord, I was according to the DT's rules. If our keeping aside everything, my lord, if 2001 the STQ letters has been sent by the department, but even 2001, well, I'm entitled to be promoted as an engineer there. Kindly appreciate, my lord, the DT's rule till that, before that, if I put this starting date on, my lord, in 2001, my lord, then prior thereto I am entitled to get promotion. That has been denied. Well, it is auto. My lord, I am working there as a helper B.
There was no further promotion available in your cadre.
No. Well, that rules I have not shown. Kindly seize, my lord, allow me to place the rules there. It is
rule you are placing?
83 rules. Kindly seize, my lord. Kindly see that rule is very important, my lord.
That 97 speaks another thing.
My lord,
initially you are engaged in 1984.
It's casual labor.
That was a casual labor, my lord.
Yes, as casual labor.
My lord.
Thereafter in 1994,
1992.
and at that time there was no post, regular post.
They are saying they have admitted in rejoinder also.
There was no regular post. They are saying that surrendering to post of scientific scientist group A gazetted category and 3 post held that the 5 post was created.
Well, it is that
1994 you are regularized. They are saying.
No, my lord, this is totally misleading statement made by me. I will show from their rejoinder. My statement has not been denied by them. They admitted that. I will show that. But before that, my lord, kindly see that.
What you will show?
My lord, kindly see that DT's policy, my lord, by which I was regularized and promoted. Kindly come to, my lord, page 24, my lord, of the writ petition.
Page
24 of the writ petition.
So that fact is not true.
No, my lord, some facts which have mislead the tribunal and court, my lord, they ultimately rejoined. I will show, my lord, my statement has not been denied by them. That means that is a clear admission there in rejoinder. I will show, my lord. I come to that, my lord. Kindly come to page 24, by which rules, my lord, I was appointed.
Yes.
Well, this was, my lord, the personal policy and practice for scientific and technical officers and staff below Group A level in the Department of Electronics and units under DOE and the Electronics Commissions. This was, my lord, 18 July 1983 at the right-hand top. May I place it, my lord? The reference is invited to paragraph 2.4 of the department's OM attached to A. Sajinsa 11th August 1981, in which it was stated that the basic features of the personal policy of Group A scientific and technical officers outlined therein would also apply. Mutatin this to scientific and technical officers or post below Group A level. With the approval of Electronics Commission, it has been decided to introduce the personal policy spelled out in the following paragraphs of S&T personnel post below Group A level, This policy will come into effect from 1st October 1983. It will be applicable to all S&T personnel posts below Group A in the Department of Electronics and Electronics Commission, Information Planning Analyze Group IPAZ or National Information Center, ERTLs, and such other units or under DOE, EC as may be specified from time to time. Then number 3, categorization of S&T post.
So you are showing this 83 circular to substantiate your argument that in terms of this policy, I was entitled to further promotions even to the post of scientific officer.
My lord.
Now that has been opposed by them, saying that no, this will not apply because we have restructured it and have placed you under non-ST cadre. This is the task of the
Main crux
matter.
of the matter.
So let us hear Mr. Gupta that what is his answer to that.
Well, before that, if I place these rules, well, I think it will.
No, your case is that my regularization was in consonance with the 18 July 83 scheme, in which I got the subsequent promotion in Helper B. After that, I was entitled to further promotions in terms of that. And their contention is no. You will not get any further promotion because now you are coming under the non-S&T cadre. This is the crux.
Well, this was, if I
Do
subject
you
your
want
lordship
to show us any other document?
Well, one document I want to show, my lord. Kindly take up, my lord, what they have stated in their rejoinder. My lord, kindly come to page 87. Page 87, my lord. Before that, my lord, kindly take up, my lord. Supplementary, my lord, supplementary affidavit, kindly take up, my lord. My lord, kindly first, your lordship, kindly come to my lord page. Kindly come to page, my lord. Kindly come to page 12, my lord. Page 12, my way, my original application, my lord. What I have stated in my original application, my lord, that should be, my lord, placed because that has not been denied.
Enumerated the post.
No.
And the year in which according to your promotion was due.
My lord, what answer they have given, my lord?
Now their stand. What is their stand?
No, what is their stand, my lord? May I place it, my lord? Kindly allow me to 5 minutes.
Which page you are
My lord,
placing?
page 12, my lord. My lord, supplementary page 12.
What?
Supplementary page 12, my lord.
What? Page 12 of the supplementary is your petition.
My lord. Because why I am placing, my lord? What they have.
What is their reply?
Their reply is, my lord, kindly come to my lord, page 87. My lord, up to paragraph 10, my lord. Up to paragraph 10, well, kindly paragraph 15 and 16 kindly sees. With reference to the statements and or contents are made in paragraph 4.7 of the said application, the deponent submits that it has already been discussed in earlier paragraph. Then, well, with reference to the statement and or contents are made in paragraph 4.9 to 4.10 of the said application, the department submits that the question does not arise and the same is not known to us. That is not known to them.
policy guidelines হবে ওই যে তুমি গাইডেড হতে পারে PIET not the recruitment rules.
My lord, 9 and 10 they're not known, my lord.
Where is that page that you page 50?
My lord, page 13 kindly sees, my lord.
They are not replying because paragraph 14 they have stated.
My lord,
paragraph 14 is their case. Page 86. Submitting it is pointed out posts of helper etc. have been restructured and declared as Group D, Grade 1 under non-ST cadre by a duly constituted manpower committee in 2001.
That is under process. I have shown the document.
That is what we are going to ask.
Now,
that if it was finalized in 2001, why did you say that the matter is still under consideration? Now, let us ascertain that.
My lord, that apart, my lord, in respect of my lord, paragraph 9, Roman 9 and 10, That has not been answered. They do not know. Kindly seize my lord, paragraph 16, what they have stated. The deponent submits that the question does not arise, the same is not known to us. No specific denial. But even paragraph 15 also no specific denial. No, it is an evasive denial, rather, I should say, my lord. It's an evasive denial. It has been specifically denied. And statement which has been by affidavit I have stated, there, my lord, that has not been denied. In the paragraph 16, my lord, what kindly sees, my lord, what I have stated in paragraph 9, that your applicant states that he has all along been treated to be under scientific and technical cadre, and he has also been given promotion following the rules.
Yes, Mr. Gupta, what is your statement?
Firstly, my lord, I would like to submit, my lord, the 1983 memorandum, whether at all it applies to him or not. Kindly come to once, my lord, the writ petition, page 24.
No, that you have said are governed by the Diet Y policy of 83.
That is policy. That is Ministry of
That is
Ministry of Department of Information and Technology.
a Diet Y.
DEI, Department of Information and Technology.
Technology, and why?
Technology.
So
Why apostrophe S?
That is policy.
That is policy. Okay, that is policy. We have a glance. It is applicable for ST. For S and T.
Yes.
Staff for S and
Scientific and technical.
scientific and
সেটা কোথায় পেয়েছো?
the policy.
83 policy.
83 policy. You take
That is at page 24.
Bhattacharya.
My lord,
83 policy where?
Page 24.
Page 24
Of
Writ petition.
of the writ petition.
Page 20. Yes, yes. If this policy will come into effect, it would be applicable to all S and T personnel.
Kindly come to page 29 once. Clause 7.4.
যা 24 it will be applicable.
May I place it, my lord?
Ignorant staff.
7.4, may I place it, my lord? All other S&T personnel will be redesignated as per Annexure 1 with their existing emoluments and service benefits protected. Page 29, clause 7.4.
7.4.
4. All other S&T personnel will be redesignated as per Annexure 1 with their existing emoluments and service benefits protected. Their cases for promotion will also be taken up in accordance with provisions contained in para 5 above, the service rendered in the existing grade counting for the purpose. Now kindly come to Annexure 1. Relevant part of Annexure 1 is at page 34. Whether at all this policy applies to him or not. Whether he is eligible under this policy or not. Page 34, kindly come once. Kindly come to serial number 30 and 31, 20 and 21, the last two. Helper B, pay scale such and such, 25 years. The age limit is, there is an age limit of 25 years to make this policy applicable to him. Today, if he is of 59 years, then in 1996, he was of 31 years. This does not apply. There is a clear age limit.
So you also said that, but your contention is?
This is not my contention is 2001 policy will apply. But assuming without admitting for the sake of argument that if this policy applies to his case, for the sake of argument, this clause stands in the way.
That point you cannot take now, Mr. Gupta.
Well, so
because your stand is, you are governed by 83 policy. We have given you regularization and promotion in terms of Diet Y policy. And thereafter, it has been restructured, bringing you under non-ST cadre.
That is our principal point, or this is an additional point what I am placing before the Lordship.
It is the age limit for direct recruit.
Lordship, grateful, my lord.
Then this policy does not apply based.
Special case, you regularize.
But then this policy does not apply at all.
You
If it
say
is
that
not a
this
di-
applies.
You says it is
Your contention is that this will
This
apply.
does not apply.
This will apply.
For the sake of argument, what I have stated, that age limit is there.
You cannot take that point after saying that this will apply.
This will apply means, my lord, for the sake of argument, I stated that. Even if this apply for the sake of argument, there is an age limit. That is what I intend to say. Now, my lord, may I place?
No, then what was, you are saying this 25 years What is this?
Age
25
limit.
age limit for
Not direct recruitment.
this is direct recruitment, page 32. So his case was not a case of direct recruitment. He prayed for direct recruitment. He was regularized. Yes.
Now, my lord, coming to 2001 policy. Firstly, my lord, the 2001 policy was available to him in 2001 itself. We have supplied that. In spite of that, for 15, 16 years, he continued to issue different letters on various dates.
Said the 2001 circular is under consideration.
That was in 2013-14. Thereafter, it was approved. That is the tribunal's observation also. There's a specific submission made in before the learned tribunal that that it has been approved.
Right, come back at 2 p.m. ফিক্সড আছে নাকি দুটোর সময়?
My lord, my question is that whether the 2001 will apply or not. Because there has been restructuring of the entire cadres of the ERTL list. ERTL stands for Eastern Regional Test Laboratory. So that, my lord, one point has been taken by my learned Mr. Bhattacharya is that whether it was approved or not. It has been approved even in the memo itself of the 2001. It has been stated that it has been approved by the Manpower Review Committee.
Then why did you say that it is still under consideration?
That is my lord. I pray before your lordship not to take consideration of that document because that document must have been, my lord, issued in some circumstances. But before that, my lord, he should make a challenge of that memo. Kindly come to the impugned order.
Page 64.
Kindly come to the impugned order, page 4.
Coming to it, it says reference to your reputation regarding service data, cadre success is under. So you have to proper to stop it. After finalization of the cadre.
Kindly come to page 4, the memo itself.
Just. We are coming. Page 7.
Cadre is reconstruction after finalization of cadre.
After finalization of cadre restructure, you will be considered for promotion if eligible.
As per the
STQCST.
Now, where is the 2001 policy?
That is in the impugned order.
Quoted in the
impugned order.
Yes.
Kindly come to page 4 of that. That is at page 4, internal page 4 of the impugned order. May I place it, madam? Subject is restructuring of non-SNT category in STQC labs regarding rationalization of designation of Group D employees and implementation.
What is this STQC?
Standardization, Testing and Quality Control Laboratories under the Ministry of Information and Technology.
Standardization,
Testing and Quality Control Laboratories. This falls under ERTA list. ERTA list is Eastern Regional Testing Laboratory.
Standardization, Testing and
Quality Control Laboratories.
So these are under the Department of Information.
Yes.
Now, he was declared to be non-STC.
Yeah, non-SNT. SNT means scientific and technical.
Scientific and
technical. He was declared by this memo as non-SNT. Clause 7. Clause 7 at internal page 6. He was restructured as Group D as Group D grade 1. Kindly come to internal page 4 of this impugned order. May I place it?
Yes.
During analysis of reports after visit of Manpower Review Committee, it has come to notice of STQC headquarters that there are total 5 Group D employees, Helper B and Helper B 3, 2 at ERTL East. This is where the petitioner was working.
Achha.
ERTL East, and 1 at ETDC Jaipur, and Helper A at Helper A 2 at ERTL East, working in technical laboratories and accounted wrongly under SNT category by labs.
So this Helper A also includes the person.
Yes. No, he was promoted as Helper B in 1996.
From Helper A to
Helper B.
Mm-hmm.
Now all these 5 persons are being correctly accounted by STQC headquarters under non-SNT staff as they are support staff. This is important, my lord. They are support staff. They are not technical staffs. They are support staffs under Group D category. ETDC Bangalore has correctly shown one helper under non-SNT category. As per recommendations of Manpower Review Committee, Peon, Helper A, B, Group D staff are recommended to be utilized in any area of lab, whether technical or non-technical, to enhance their utilization and are to be shown under non-SNT category only. So the recommendation and approval is there. Approval is also there. I shall place the
Utilized in
reply.
any area of lab. They
Any
were
area
not
of
in
lab
the lab.
means ERTL, ERTL East. Laboratories falling under the ERTL East.
What
And
is
also Jaipur.
ERTL? What is ERTL?
ERTL is Eastern Regional Testing Laboratory. Electronics Regional Testing Laboratory, which is situated in Salt Lake, Sector 5. This is the eastern area, is wholly covered under this ERTL East. For example, the western area is covered under ETDC Jaipur. So this is the policy, my lord. Now, my lord, kindly come to our rejoinder where we have clarified that. But before, kindly come to our rejoinder, my lord, that which starts from page 80.
Now,
Of
please
the
read the next paragraph. Presently, there are 8
8 persons working as Group D, including Helper B, in the pay scale of such and such as mentioned below. As there is no sanctioned post in the pay scales of 2650 to 4000, after cadre structuring of non-SNT staff, competent authority, this is important, my lord, competent authority has approved that the designation of these persons should now be changed to Group D Grade 1 and given pay scale of 2650 to 4000 as personal to them against sanctioned post of Group D Grade 1.
This was given to them.
Yes.
This
That-
was helper A or helper B, 2650.
Helper B.
This is the promotional post.
No, this is restructured post. This is Helper B is restructured as Group D Grade 1.
So he got promotion is helper A in 92.
92, thereafter Helper B in 96, and in 2001, he was restructured as Group D Grade 1.
In terms of this memo.
In terms of this memo.
So he became Group D Grade 1.
Group D Grade 1.
Under non-STS.
Non-ST. Now, my lord, may I continue, my lord? Thereafter, in view of above, competent authority has approved that ERTL East, ETDC Bangalore, ETDC Mohali, and ETDC Jaipur may make corrections as shown below accordingly in their manpower database and in their service and personal records of individual concerned by changing designation of Helper A, Helper B, Helper 2, Group 2, Group D, Grade 1, and shown under non-SNT category instead of presently under technical category under confirmation to STQC headquarters. So thereafter, page 6, clause 7, the petitioner, ERTL East Kolkata, pay scale, thereafter Helper B, SNT, thereafter he was restructured as Group D Grade 1 in the same pay scale, personal to him, non-SNT. Now I will kindly come to page 42 of the supplementary affidavit. My primary submission is that he has to challenge the memo because this is a policy decision of the union. It cannot be a bare and evasive challenge. It has to be a specific challenge.
No, if it is not, if it is under consideration of authorities, what he will challenge?
No, it was approved by the authority, competent authority. The memo itself says.
Sure, but in your RTI reply, you said that it is under consideration.
Maybe he was misinformed. The concerned authority was misinformed. I pray before your lordship not to take recourse of that RTI reply, because that becomes inconsistent with the memo itself. So that part has to be abrogated.
The manpower.
Review committee. Yes.
Recommendation of the manpower.
Thereafter, competent authority has approved that.
Accepted that recommendation.
Competent
But
authority.
where is that?
Competent authority has approved that. That is written in the memo itself.
So
Competent authority means memo, ministry. That has to be.
But where is that approval? Do you have that approval?
No, that I do not. That I do not. The memo itself says, I do not have that. Competent authority has to be the ministry, because Ministry of Information and Technology is the competent authority over the STQCs, over the Manpower Review Committee.
সেটা এখানেই বলেছে।
He is
personal to them.
He is aware of the 2001 memo from 2001 itself. He never challenges that.
না না, তার আগে পেজ 5 এ sanction posts are for after cadre researching competent authorities approved it.
He is aware of the memo of 2001 in 2001 itself. In 2016, he never challenges that. But prior to 2016, all the original applications which were filed by him, which were culminated into the writ petitions before this honorable court, all were regarding regularization of his past service, alleged past service. Only in 2016, he comes up with a plea, but that was unclear altogether.
To the director. To the director.
The manpower
issued this order. Who issued?
Ministry করেছে।
That is the original policy, is not with you.
No, that is not with.
Who issued? It is addressed to all directors.
Yes, all the ERTLs, all the regional laboratories.
All the director, yes. Director of all.
Regional. There are four regional laboratories in 4 parts of India. They were directed.
No, the tribunal says you have brought it on record with the reply. Page 3 of the order. Paragraph 4. It is a fact restructuring policy was introduced with approval of Government of India.
Yes, yes.
Which has been brought on record by the respondents along with his reply.
So now, my lord, kindly may I place the reply?
In reply, you have stated, where is that annexure? Reply you have stated in paragraph 14.
Yes. Before that paragraph 6 also I have stated.
Paragraph Manpower Review Committee of the year 2001.
Yes.
Now, where is this original memo? 12th March 2001. Have you annexed that?
No, that I have not annexed. The recommendations are there, which I have annexed. That is at page 97 is our reply. Page 99 is the order. Page 104 is the order of the writ petition. Previous writ petition, thereafter review.
99.
99 order in the earlier writ petition, thereafter review. Review is 107.
Yes.
Page 108, the middle portion. Today, after disposal of the lease before this court, the authority is free to decide its promotional avenue in accordance with the service rules. The relevant service rules is 2001.
Where you are reading?
Page 108.
Yes.
Page 108.
You were
line from the
waiting.
top.
Review court observes that you were waiting for a final outcome of the court.
Yes, yes.
So that issue was pertaining to retrospective effect of regularization.
From 84 to 92. That was the challenge
That
by
was the
him.
challenge. So court said that is also reflected in your order.
Yes, in 9th March's departmental order.
But the thing is, court said that you have kept it in abeyance since the matter was pending. So court said that you will be free to decide the promotional avenue in accordance with the service rules.
The service rule does not have, does not, my lord,
No, you now say that the original service rules of the DIET policy, 83 policy is not applicable.
not applicable. Because
They are to-
2001 he has been restructured as non-SNT.
Where is that memo? This
That
restructured
is the impugned
quoted in the order. Who has issued it? As my brother was asking, who has issued it? And mm, why this memo was issued under RTI saying that it is in process, not only once but twice, because that you have stated in page 64 and 77.
that part becoming inconsistent. At best I can submit that those two replies are inconsistent with the original memos, so that part has to be abrogated with. As that much I can submit, my lord, at the best. Because now what is there in RTI reply, I cannot say that no, it's a suspected document or whatever. I am not saying
Then
that.
how can you overcome that?
Because the reply in the RTI becomes inconsistent with the memo itself.
So please show us the requisition on the basis of which you issued page 64. What information he wanted? This page 64 is in reply to which RTI? This is 13 December 2013.
This has reference to representation. The earlier page is the representation. একটু কপিটা দেবেন তো, আমারটা পড়া যাচ্ছে না পেজ 64 টা।
প্রথম
The process.
This is reply to what? 13 December.
This has reference to your representation regarding service matter, cadre restructure of non-SNT posts in STQC in under process in consultation with Ministry of Finance. Must be in respect of the 12th October of the representation.
Page 63.
Let him challenge the memo. He has not challenged the memo.
I reiterate that I have previously corresponded. Also, the contents as stated here. I has requested to immediately provide me a portion so as to enable me to achieve my goal in STQC. STQ. He was regularized in view of STQC policy.
STQC policy is not that. He was regularized in respect of created posts. Posts were
Personal to
created.
them.
Yes.
No,
5
you
posts were
issued that
created.
memo, na? That memo where it is stated that this will not apply. It's
Page 24 of the writ petition.
page.
Page 24 of the writ petition.
No, page 58 of the writ petition.
Oh,
Please
that I shall explain. That I shall
please
explain.
explain us that.
Yes.
So your contention is 2001 is not under challenge. So it was known to them.
Yes.
And the memo itself reveals that it got the approval from the competent authority in 2001.
But before 58, my lord, kindly come to supplementary page 109. The approval part is there. Supplementary page 109. This is annexed to our rejoinder reply. This is to all the directors of STQC labs under Ministry of Technology, ERTLs, ETDCs, and CFR, issued by the Government of India, Ministry of Information Technology. Subject restructuring of non-SNT category cadre in STQC labs regarding rationalization of
only first page has been added. Next page has not been.
So the relevant part is there. During analysis of reports after visit of manpower.
Competent authority has approved.
Yes,
That
last
these
paragraph.
Arises since your officer state that The cadre restructuring of non-ST cadre.
Yes.
Although non-ST employee are under post, is under post.
My lord, that cannot be stressed upon because that becomes inconsistent with all these documents. RTI reply is not sacrosanct when the other documents are there. This document, page 109, clearly says that competent authority has approved. Now, my lord, kindly come to page 42 once.
No, please come to page 58. Explain to us what does it mean of the writ petition. Application of
This is dated 21 December 2015.
seeking recruitment rules for the post of helper A and B.
Yes, paragraph 2. He is right in stating this. As this is my response to submission. In this regard, it is stated that below Group A S&T officials, including helper A and B, are governed by the Deities policy of 1983 and amended from time to time, not by the recruitment rules.
Which are the recruitment rules?
2001. But this does not apply to him. Kindly see the date. 21/12/2015. At this date, he was a non-ST category. This memo speaking about helper A and B, S&T category. At this date, he was not an not a S&T category personnel. This memo is speaking about Group A S&T officials and Group A helper B, A and B.
On the basis of which he is relying upon the recruitment rules at page 24. 83 policy.
83 policy.
So in are governed, you are saying?
This is 2015. He was already designated as a non-ST category.
In 2001.
2001.
Now, what you are saying, what does this mean? Below Group A S&T officials.
This memo, this reply speaks about S&T officials. So obviously, it is correct. This memo is correct, but it does not apply to him. This memo is correct. This speaks about S&T officials. He has nothing to do with S&T officials after post 2001. He made a query of S&T officials and the query was replied. Kindly see the subject part.
That entitles him to the 83. He has not heard it. That promotion না দিলে আর challenge ছিল যে আমাকে 84 থেকে ইয়ে দিয়ে দিল তারপরে সেইবার শুরু করলো যে এইটাকে নিয়ে অর্থাৎ 2001-এ ওকে অলরেডি গ্রুপ ডি করে রিস্ট্রাকচার পোস্ট করে ওকে দেওয়া হয়েছে। 14 বছর পরে রিস্ট্রাকচার করে ওকে দেওয়া হয়নি, ওদের পোস্ট ওই হেল্পার বি তে ওকে কন্টিনিউ করতে বলা হলো পার্সোনাল উইথ পার্সোনাল। এবার রিস্ট্রাকচারিং হয়ে ওদেরকে বললো নন এসটিএস 51 নন।
Kindly come to page 58 once more.
58.
58. Kindly see the subject. Application of Sri Ajay Kumar Dhar, Group D Grade 1. It is described that he is Group D Grade 1. What he is seeking? He is seeking recruitment rules for the post of helper A and B. Obviously, the 83 policy will apply for helper A and B. But he is a Group D Grade 1.
No, you are saying it will diet policy of 83 will apply, not
for helper A and B, but he is a Group D Grade 1. So this answer does not go in his favor.
So after restructuring, he became Group D Grade 1.
Grade 1. Had he queried about what is the recruitment rules for Group D Grade 1, then the reply could have been come that the 2001 policy will apply. He asked for helper A and B. Minister concerned authority said that 83 policy will apply. This has nothing to do with him. He is a Group D Grade 1 non-SNT category. Now, my lord, kindly come to page 42 of the supplementary affidavit.
Of supplementary.
Supplementary, only one paragraph I shall show. This is This is a letter dated 17th May 2001, written by the petitioner to the director of the Electronics Regional Test Laboratory East. Kindly come to I shall only place the first paragraph. Subject recruitment of non-ST category in STQC labs regarding rationalization of designation of Group D employees and implementation. A copy of the Deputy Director STQC Directorate letter number such and such dated 12th March 2001 on the above subject has been handed over to me. On going through the same, I find that the posts of helper B and helper A are being accounted under non-SNT staff, and the reason that has been advanced is that these posts were wrongly accounted under SNT category by labs and they are support staff under Group D category. So in 2001, this letter is of 2001, he was aware of this thing. In spite of this, he wrote umpteen letters to departments harping on the point of his regularization of his past services. Even in 2016, in the original application, he did not challenge this order. There's a vague challenge. All the
2016 review court said that you kept silent because his cases were pending.
Question of seniority doesn't arise because Group D Grade 1 post.
No. Come to the review application order.
Yes.
Court said that as so long, that is up to 2016, you have kept in abeyance his claim, saying that it is sub judice. Then the court said that the sub judice was on the issue of retrospective effect to be granted or not to his regularization.
Yes.
But this area has not been considered.
Considered because it was never challenged by the writ petitioner.
No. Let us understand. So from 2016, it was not considered. Review court said you would be at liberty to consider.
Yes.
Then you did not make any communication.
Yes.
But he made repeated representation. Ultimately, in the reply to the original application, you said, that is at paragraph 10,
Paragraph 14.
that it has been restructured.
Yes.
And
so this is the communication of 2001 where we have already stated to him that it has been restructured. In spite of that, he did not challenge. 2001, now we are in 2024. So it was with him in 2001, this memo. He did not challenge that. Even in this OA, the prayers, kindly see the prayers of the OA.
That is a vague prayer.
Vague prayer, absolutely vague prayer. And now lastly, my lord, I shall place the impugn order once again. The observations of the impugn order. Why the original application was dismissed.
চ্যালেঞ্জ করেনি সাবসিকুয়েন্ট প্রফেশনাল পোস্টের জন্য সেকশনে যায়
Mr. Gupta, helper A and B, it has been subsequently kept after S&T category. Now
non-SNT.
Now it is filled up by direct recruit.
Yes. No,
but in respect of this particular 5 or 8 employee, they have been category structured as Group D and personal.
Because they are support staff.
It is not. It is not clear whether this.
Because they are support staffs. They are not technical staff.
Support staff. Whom you are saying support staff?
Support staff means who are supporting the various. My lord, what to say, my lord? They are not engaged in technical work.
Regularize him helper B.
Helper B.
Helper A.
Helper A,
Thereafter, he got promotion in the post of to the post of
helper
helper
B.
B. Thereafter, helper B. That post with same nomenclature has been you are maintaining under S and T category.
Till 2001.
No, still there, till the day.
No.
Now you are filling up that post through direct recruitment. Otherwise, why you are showing that the age 25 now?
But they are,
You are showing.
but they are support staffs.
Suddenly, you segregated 5 employee or 8 employee, whatever.
The reason is that they were support staffs
Classified them as group D1.
because they are
That's
support
what
staffs,
for us.
my lord. Because
What was the cause of such segregation?
because they were support staff, that is there in the memo. They were not technical staffs.
Where is that? In the memo?
In the memo, it is there, page 4. Support staff are not technical staffs. Sup- Support staffs are not technical staffs, my lord.
Where is it dated that?
In the memo,
Memo page, internal page 4
internal page 4
of
of
the
the impugned order.
of your memo.
Of the impugned order.
Where you have quoted the memo.
Yes.
Internal page 4, yes. Where you are getting their support staff?
Page 4, my lord. May I place it, my lord? During analysis of reports after visit of Manpower Review Committee, it has come to notice of STQC headquarters that there are total 5 Group D employees, helper B, such and such, working in technical laboratories and accounted wrongly under SNT category by labs. Now, all these 5 persons are being correctly accounted by STQC headquarters under non-ST staff as their support staff under Group D category. Support staff is not technical, does not fall within technical category. Support staff, for example, he was employed at night. Even he was employed as gatekeeper also once. So these are support staffs.
You kindly take us that you are showing age 25, that
Page 24.
page 24
Page 24.
of supplementary bill.
No, writ petition.
Page 24. Page 34, you come. Page 34. Helper PA. Then now,
That is age limit for direct recruitment.
now come to page 32. It is educational other norms of the direct recruitment to the group B, C, and D scientific and technical post in the department of electronics such and such. So it is scientific and technical post. So helper B and A is technical posts.
That has been clarified by the 2001 memo. That is the wrong what has been committed. That is what has been rectified. Because support staff cannot be technical post. That is what the memo says.
এটা হচ্ছে notification.
Annex
What are the
2.
recruitment criteria
Criteria.
of technicals?
Technical.
সেটা বলছে ডিরেক্ট রিক্রুটমেন্ট এইভাবে হবে।
এইভাবে হবে, হ্যাঁ।
কিন্তু ওদেরটা তো
এটা হচ্ছে 93 policy.
83 পলিসি।
83 policy.
এখন ওরা তো সাপোজ ওদের রেগুলারাইজ করে দিল, পার্সোনাল টু দেম রেগুলারাইজ করে দিল গ্রুপ বি গ্রুপ এ, এবং ওই পোস্টটা ডিসকন্টিনিউড হবে আফটার দেয়ার।
After that.
2001 memo is not under challenge, my lord. These issues, my lord, are in fact, my lord, infructuous presently.
Yes, what do you want to show from the order?
Impugned order, my lord. The reason why the OA was dismissed. Kindly come to internal page 8. Paragraph 6, my lord. Therefore, a short question for consideration before this tribunal is that whether the applicant belongs to SNT category or non-SNT category. The applicant claims the category of SNT on the basis of job he is performing at present. 8. The letter dated 12th March 2001 referred herein above makes it abundantly clear that all the 5 Group B employees helper B who were earlier designated wrongly wrongly term is used by different labs were now correctly put by STQC headquarters under non-SNT staff. He was appointed as such in pursuance of this order in the year 2001. That order has not been challenged by the applicant in his original application. A relief has been claimed that whether order whenever passed should be set aside wherein the applicant has been declared non-ST staff. It is noticed that the order passed on 12 March 2001. He did not challenge the order specifically, probably for the delay in preferring the application. Paragraph
So
9.
why you are saying he was appointed as such in pursuance of this order of 2001?
He was restructured as non-SNT. That is what is the intention of this statement. Paragraph 9, my lord, may I place it? As in view of the restructuring, the mistake was correct, and all the 5 Group B employees working as helper B in different laboratories and in headquarters were designated as non-SNT staff. Hence, we are of the view that presently the applicant should be treated as non-SNT category. The order which has attained finality after lapse of time, wherein he was redesignated as non-SNT category, the challenge cannot be sustainable. Accordingly, the relief one which the applicant has claimed in the OA cannot be allowed. Now, my lord, this is also important, paragraph 11. There is one more important fact to be noticed, that is in 2007 selection process was initiated for promotion to the post of assistant A, but the applicant has not participated in that selection, claiming himself to be in category of SNT, and in the OA he claims that he is not supposed to undergo a trade test of typing, which was an essential requirement for promotion to assistant A. So he did not take part in the selection process. He could have been promoted if he had been succeeded. So in my respectful submission, my lord, this impugn order is a valid and reasoned one, my lord, and there is no scope for interference in this.
All right, thank you. Yes, Mr. Bhattacharya.
But if your lordship takes up the nature, it is not an order, my lord. Kindly respectfully submit, my lord, this is not the order issued by the government. It has not recommended by the or assent from the Ministry of Finance. My lord, any.
That is page 42. It was given to you of the supplementary affidavit.
No, my lord, what my land
That was given to you way back in 2001.
2000. Now kindly.
All these points were not raised by you, Mr. Bhattacharya.
Well, I raised. I'm coming that, my lord. Kindly come to page 5. Page 5 of the order impugned, my lord.
Yes. Page 5 of the order impugned.
My lord.
Yes.
Kindly, my lord, see, my lord, last 2 lines. And shown under non-ST category instead of presently under technical category, then very important, under confirmation of STQ headquarters. Yet to be confirmed, my lord. Kindly see, my lord. Under confirmation to STQ headquarters. Now, my lord, kindly read this thing with the reply given by the, my lord, officer at page, your lordship, just, my lord. 38. Kindly, my lord, read along with the 58, my lord, page 58. Before that, my lord, kindly see the 57. It is under.
No, in view of that, you are reading from the memo.
Memo? That memo he is relying upon.
That memo, apparently, what shows is your argument was this was never given. This was never given. Did not receive any confirmation from the competent authority.
Yes.
But this was given to you, copy of this was given to you in 2001.
Yes, well, they asked for MACP acceptance, they asked for before.
That is separate. MACP acceptance is separate.
But
That
in
is
view of this, they asked for MACP, my lord. I have denied.
We were wondering that their contention is See, Mr. Bhattacharya, it is not a case out of the 8 helpers, some has been given the ST cadre and some has been given, so discrimination is not there.
Yes, there. I will show. I have filed my supplementary application, my lord. There
You cannot extend the ambit of your application.
No, I cannot admit, but
Then, Mr.
my lord, the facts I should brought before your lordship, my lord. What has
That
been
we
happened?
have seen, Mr. Bhattacharya.
No, that application has not been placed before your lordship, my lord.
Which application you see?
My lord, kindly take some, my lord, the application, my application, my lord.
Yes.
My lord, kindly take some, my lord. Scan 2572.
What is that?
That is pending before lordship, my lord.
That is replied in the impugned order of 9th March 2006. He raised a point, but that is replied.
Can
2572, my lord.
2572. Yes.
My lord. My lord, kindly come to page 11.
এটা অলরেডি কোট হয়েছে সেটা যেটা তুমি বলছিলে ফুল বিভিন্ন ইয়েকে ডিস্ট্রিবিউট করেছিল by the deputy director of the Ministry of Information.
Kindly come to page 11, my lord, of that
Page
application.
11.
My lord.
Yes.
My lord, paragraph E. If I place, my lord, kindly allow me to place it, my lord. That the respondent authorities through an office order as recorded in the impugned order under challenge before this honorable court in the instant writ application seeks to override the provisions of the fundamental rules in as much as office order 12/2001 seeks to make the pay of the petitioner applicant personal to the substantive post held by the petitioner applicant as his regulation. That it was impermissible with the fundamental rules to make pay to substantive post personal.
This is
Then
a new ground.
No. But this is additional. Then, my lord, kindly turn the page. Kindly come to my lord. My lord, kindly G kindly sees, my lord.
Page
12. Para G. The instant office order 12 March 2001 as recorded in the impugned order was neither a recommendation of the pay commission nor notified in the official gazette for being accorded any legal sanctity that in effect sought to override the fundamental rules.
That is exactly we are asking that why
Yes,
didn't
let
you
them show the
challenge it?
official my gazette notification that was gazetted and accept.
You have annexed it, page 18 of the same application.
But that is a letter issued by the
Mr. Bhattacharya, this non-effectivity of the memo of 12th March 2001 due to lack of gazette notification, etc., that goes contrary to your original argument. Your original argument was what? That 12th March 2001 memo from the reply to the RTI would reveal that it was still kept in abeyance. It was not having the sanction.
Therefore, well, that is my.
But in your reply, you yourself had admitted that 12th of March was given to me.
Yes,
and
but
I replied.
My penultimate paragraph of the application.
Mr. Bhattacharya, show us where is the challenge to that memo in the original application.
Original application, my lord. Kindly, my lord, kindly seize, my lord.
It is not there, Mr. Bhattacharya.
It is there.
You have tried your best.
My
What
lord,
can be done?
my lord, kindly, my lord, kindly take
You have
my
tried
original
your
application.
best, Mr.
My lord, no, my lord. I will not take more than 5 minutes.
You have taken half an hour, sir.
My lord, now I will not take more than 5 minutes, my lord. Kindly takes up, my lord, my paragraph at page, my lord. At page, my lord. Page 13 of the original application.
13.
Wait.
13. Yes. Clause 9.
My lord, kindly says, my lord, Roman 8. He had made continuous representation, application, etc., etc. Then, my lord, since decategorization has taken place from scientific technical to that of non-scientific technical, has case would be taken up only after finalization of the same. Then next paragraph, my lord. All along has been treated, etc. Then I annex the 12 March 2001 notification there. Had that been the case, I have not challenged it. I will not annex that. Then, my lord, the memorandum I have shared, my lord, stated that the 1983 memorandum is guided to my service.
Oh, read.
Then, my lord,
Mr. Bhattacharya, go slow. You are clause 9, para 9, next page. The service status of the applicant thus cannot be changed by applying the 2001 simpliciter.
my lord.
So this is your statement. So where is your specific challenge in the year 2016?
My lord, then kindly see that.
Now you come to your
paragraph 10, my lord, paragraph 10, kindly see. Designation group D employees and implementation. It was replied on behalf of the respondent authorities by their reply dated such and such that no material information is available. With STQ DT, your applicant further state the information obtained from the PG portal, Department Administrative Reform Public Grievance, your respective grievance ventilated by the applicant. Cadre restructure of non-ST is under process. After finalization, he may be considered for promotion if eligible under recruitment rules. Then, my lord, last two lines. Further, it is also non-deniable that the promotional aspects of the applicant is to be considered as per the recruitment rules. As per the version of the respondent authorities itself, it is pertinent to mention here that the applicant has been appointed promotion under 83 rules, DT's rules, and the same is still in force. It is not that this order in superseding to the rules, my lord, then could have a case of the government, my lord. The rules is still subsisting. My lord, it is not the case, my lord, the post, what my land stated before, Lord's will, the post has been created, not that. And so, had that been the case in 83 rules, my lord, there would not be any post of helper A and helper B. It was
then why didn't you appear in the test for assistant engineer?
So that is according to 2001. I am denying.
2007.
No, 2007 as per the later.
As per the STSC.
No. It is as per non-ST.
No. Come to the order. Paragraph 11. Selection process was initiated for promotion to assistant A, which according to the 1983 policy, but the applicant has not participated in the selection, claiming himself to be a category of S&T.
S&T means scientific and technical trade.
Yes.
A scientific and technical cadre. That's why I would not appear.
Why?
Because they're asking this assistant A post, but according to the subsequent 2001. That's why I didn't appear. My lord, keeping aside everything, my lord, if before issuing this letter in March 2001, I, my lord, should promoted to the engineer in 2001 itself, when I got the, my lord, decree with approval from the department for getting my lord, education, extra education. My lord, 96, I was last promoted. Thereafter, 99, another promotion due. Then 2001, another promotion due. Therefore, that will be evaporated. Even for the sake of argument, if I admit that this 2001 is a new designation approved, my lord, what about my past promotion? That will be evaporated automatically.
All right.
And my lord, 2001, I with due respect submitting, my lord, it has not been brought to the light of the day because it has been approved by the Minister of Finance. And my lord, one thing more.
Yes.
My lord, one document more, my lord. Kindly allow me.
Yes.
Page 57 of the writ petition.
Page.
What my line of friend saying that it should not be looked into. My lord, kindly sees. Page 57 of the writ petition, my lord, kindly sees, my lord. There I ask what I am asking, my lord. Certified or attested copies of the recruitment rules of a helper A, helper B, laboratory assistant A, and a copy of the group D cadre 1.
Page
57.
Writ
petition.
Copies of
recruitment rules of helper A, S&T, helper B, S&T, laboratory assistant, and a copy of the group D cadre. And what answer they have given, my lord, kindly come to page 58. In this regard, it is stated that below group A, S&T officials, that means my post, including helper A and B, are governed by the DT's policy of 1983 and amended from time to time, not by the recruitment rules. Therefore, that rules is still subsisting. My lord, 2001 letter, it's a letter. It is neither a notification, nothing. My lord, it has got no legal force at all, my lord. Even if I say, my lord, I have not challenged specifically, but my prayer is there, prayer B of the original application is there, my lord. I have categorically stated in my statement in the way. Well, even then, my lord, I should say, my lord, the thing which is not acceptable in the judiciary, my lord. Why it would be, my lord, given something to be in the order, my lord, which has never been given effect to. Well, had that been the case, my lord, this CPIO, he ought not to have replied. It is serious. Well, he is my lord, holding a serious post. My line friend saying that he should not be looked into by the court.
The learned advocates appearing for the respective parties.
And my lord, for the last 30 years, I am working. I am not getting any promotion. This is these things and this fallacy has been taken out by my learned friend.
He was invited for promotion. He refused to.
No, this is not
appear
a,
in the
this is not
examination.
all throughout years you are saying, and my lord, in rejoinder, he said he didn't give any specific statement, not denial.
We have heard you, Mr. Bhatt.
I am grateful to you.
Yes. এইবার পার্ট ফাইলটা সাহেবকে পাঠিয়ে দেবেন, আমার ফাইলটা আমাকে পাঠিয়ে
I'm for the petitioner, my lord. My lord, this case is relating to, my lord, porters, my lord, railway porters. My lord, the porters are two types, my lord.
Hey, you go to the
License-
regular bench. This has not been extensive. Mr. Ghosh, go to the regular. My lord, go to the regular bench, Mr. Ghosh.
Lord, your lordship heard the matter, Lord. Your lordship kindly see. We are. Lord, there is a limit. Lord, if we cross the age limit, Lord, we will be deprived of the short matter. Lordship heard the matter in part, marked it as part heard, and fixed the date on 11th November.
May I start, my lord?
Now, earlier occasion the tribunal passed similar order on following that. Yes.
Yes.
Lord, my lord. Before I start, my lord, this is relating to porters, railway porters. Porters are of two types, my lord. One is licensed porter. Licensed porter is those porters who carries the luggages of the passengers. Their dress is different, their badge is different, their license is different. And another type of porter is a parcel porter. The parcel porter is those porters who carries the luggages and parcels of the railway department. And their dress, badge and license is entirely different. Licensed parcel porters are not allowed to carry the luggages of the passengers and vice versa. And by my lord, order dated, my lord, 38/7/1997 at page 27, annexure 3, my lord, it is clearly stated that in case they are to be used for handling parcel, they should surrender their fully license. So, my lord, one license porter cannot carry the parcel.
Page.
Page 27. This is the order dated 38/7/1997. This is the fundamental questions that one type of porter cannot work the other type of goods. Then, my
Yes,
lord,
page 27. What you are showing?
this is the Government of India Ministry of Railway, my lord, order number 70 oblique etc. my lord, New Delhi 37/1997.
What are you showing?
But the second paragraph, the matter has been examined in board office in the light of the court judgment of the similar cases and their implications. It has been decided in separation of the ports in instructions to event date number, etc., that the licensed porters should not be utilized for parcel handling work as they are granted license for carrying passengers luggage only. In case they are to be used for handling parcels, they should surrender their courier license. So it's clear, my lord. Then, my lord, kindly come to the impugned order.
So they are licensed porters. They are licensed porters.
Yes, they are licensed porters for carrying the.
Yeah, sir. So the respondents herein are the licensed porters.
Yes.
To carry the
Licensed porters are
Yes.
the persons who the porters who carries the luggage of the passenger.
Yeah.
Madam, kindly come to the impugned order, madam, impugned judgment. At page 3, the ordering portion starts.
Page
3 of the inner page 3, my lord, on impugned judgment. The applicants who are initially used to carry passengers' luggage in Malda station premises to the on the basis of license granted by the railway administration, where subsequently, first is that they are licensed porters. License granted by the railway administration, were subsequently utilized for departmental jobs, that is loading and unloading of railway parcels and consignments. My lord, this is a disputed question. This is their point that they are given license for carrying the luggages of the passengers, but they are subsequently utilized according to their conversion used by the railway authority to carry parcels, which is according to law is prohibited as per that order. The railway stopped renewing the license and the applicants continued to work as parcel porters under railway before 2009. Kindly mark this portion. According to their conversion, before 2009, they are already carrying parcels of railway authority. So they are.
That was in derogation to the license they were enjoying.
Yes.
That was in, they were not entrusted for the said job.
Lordship. And
very good now.
According to their contention, before 2009, they are already doing the job of parcel porters. And before that, they are holding the licensed porters license. Long after their continuation of performing jobs of railway goods and parcel upon the direct supervision of the employment of railway authorities, they were issued identity cards by the station manager mentioning there in their working place, name, designation, date of birth, blood group, identification marks, etc., etc. Their monthly attendance used to be maintained by the commercial supervisor Malda town, wherein their
all the persons are alive.
Yes.
Or anybody has expired.
During pregnancy, they are alive.
Alive. All the persons are. Yes. Yes.
It is to be also stated that these licensed porters is to be paid by the passengers.
Please place the order, then you can
Yes,
argue.
That the nature of job the applicants are performing are perennial and essential for the railway administration. The applicants have acquired temporary status as per provision of railway establishment code, etc. Upon performing 120 days continuous job after their engagement by railway administration casually for the departmental job of railways. As aforesaid, that quite unfortunately the railway administration taking advantage of their dominance and the applicant's poverty extracted service of 24 hours a day and paid much less than the minimum wages for labor as fixed either by the state or the central government. Documents showing the performance of the departmental job are in paid, etc., etc. That in spite of their repeated demands, they are not being paid minimum wages. Then, my lord, railway administration have all along avoided their absorption and regulation. They admitted that their railway administration has not been absorbed and regulated. That means they are not given the certificate or license of a parcel porter. This means that the railway administration have all along avoided the absorption and regulation.
So what was
That
their
means
temporary status granted?
Their status is they are still licensed porters. They are licensed porters, and their contention they are
So
working.
you have subsequently given them temporary status. Have
that
they
is their
been
contention.
regularized? They were not regularized.
That is their contention, but my document shows that they are.
All right, you place the order, then we will listen to your.
they were paid some money on monthly basis from year 2009 to December 2011. Thereafter, subsidy payment system was introduced and the railway authorities stopped their payment. Aggrieved and applicant performed the representation to the authorities concerned, but no avail. Such evidence contents of their union of their unions of to prepare representation, paying for the regulation, absorption, and payment to due to the thereafter to joint approach to tribunal with the prayers mentioned above. Per contra, the railway administration have filed their reply by saying that the identity cards said to have been issued are not in proper format and allege that the signature on the attendance register are fake. That the identity card were issued by the H.K. Singh, the station manager. He was subsequently admitted and confirmed his signature and stamp on the photograph while he was working as station manager temporarily prior to the confirmation of his post of station manager. That not a scrap of paper has been produced before this tribunal to show that since they have been working as parcel papers, license was either granted or renewed in their favor by the railways, which has been countered by the applicants on the basis of the identity card annexure number 11, etc. That in the Mandal railway station there is no post of parcel porter, which has been refuted by the applicant, saying that availability of post is not at all necessary as held by the tribunal in a similar case of the other stations, etc. While similar stance taken by the railway has been rejected and the railway administration have been directed to absorb them as parcel porters or any such similar job in view of their continuous working. Then, my lord, this is a admitted position. I don't know how it is admitted because the railways have admitted that the applicants have been working in loading and unloading of parcels at Malda station, and accordingly, the divisional commercial manager railway requested the divisional railway manager Eastern Railway Malda to take appropriate steps for their payment. A copy of such letter is annexed page 12 of the rejoinder. If your lordship kindly comes to the rejoinder at supplementary affidavit submitted by my senior friend, thanks to him.
First, you finish it off.
Lordship.
Just a moment.
Regarding payment, it is an
So did you file the report as called for earlier?
My lord, already report is submitted.
It has been submitted.
Report.
No. Order dated 1st February 2003.
I think report is submitted long before
given.
Yes. There's a huge bunch of papers.
Is it?
Yes. It was yes, dated 29/7/2022.
বলেছিল taking step for compliance. বাবু এটা স্টেপেল করে আলাদা রাখুন, এটা ফাইলে পরে ঢোকান। Yes, where are you reading? Come.
Admitted position that they have been working in loading and unloading of parcel. That is parcel porters. Then divisional commercial manager.
And according to divisional commercial manager, railway requested the divisional manager, etc., to take appropriate steps for their payment. A copy of the such letter is annexed at page 12 of this rejoinder. Rejoinder, I shall show you, lordship.
Yes, you'll show us later. Please.
Regarding payment, it is an admitted position that the applicants have not been paid since December 2011, and even after the letter At page 12, the rejoinder of the respondent failed to produce a single scrap of paper, so payment made thereafter. So payment is not been made. The disputed stand, the respondent in paragraph 13 of the reply have specifically stated that the applicants were engaged as licensed porters and enclose a list of licensed porters, but nothing has been actually enclosed. They would deny that the applicants were even authorized and worked for the loading and unloading of parcel, which is untrue, as would appear from 12 of the applicant's rejoinder and annexure A1 of the AO. The legal position, my lord, here is one judgment referred, and my contention is that the fact of the judgment is totally different from this fact of the case. The judgment is referred, my lord. I am reading, my lord. We first consider the question about the status of the applicant 1 to 40. It is not disputed that these applicants were all initially engaged as contract labor for handling loading, unloading, and transshipment of parcels of Bhagwalpur railway station and were being paid by the
Where
railway.
you are reading?
Well, the small letters. Bottom, last paragraph. And were being paid by the railway through the contractors as per terms of the agreement, though they had to work under the direct control of the railway officers. After termination of the contract, the applicants formed a labor cooperative, that is Bhagalpur Junction Railway Labour Cooperative Society Limited, and a contract was entered into with this cooperative by the railways to do the same work in place of the erstwhile contractors, and the applicants continue to parcel handling work, and thus they have rendered service to the railway for a long time. My lord, in this case, these persons all along work as a parcel porters. First through contractor, then after creating a cooperative, then directly.
No, they were initially engaged as contract labor for handling, loading, unloading, and transshipment of parcels.
The parcel, that is means railway parcels, not as a licensed porter. They were working as a parcel porter under a contractor. So this case is entirely different. And here case, my lord, in this case, my lord, it is undisputed that they are given contract. They are the license of licensed porters, and they were working as licensed. Subsequently, they were given unauthorized work of parcel carrying. So this judgment, according to my submission, shall not apply. But on the basis of this judgment, my lord, if your lordship kindly comes to end of this judgment, that from super it is that the present applicants are identically circumstanced and therefore deserve the same relief. Further, that even in absence of regular parcel porter post, the authorities
don't read that. Your argument is it is distinguishable on facts.
Lordship.
This is your argument.
Yes.
Now, what has happened to that? Ultimately, what you have done with those persons?
My lord,
the persons in that
direction was given to absorb.
No,
those parcel porters.
No.
In this judgment.
In this judgment, page 10, after continuation of that judgment, this judgment is hold that judgment after holding
will
that
apply in respect of others.
Yes, for these applicants, my lord. That's
how. What is the OA number in this case? This is OA 1517.
My lord, the judgment referred is OA 158 of 1997, 1392 of 1997, and 1400 of 1997.
Not
At
this
page
OA.
6.
This OA is 1517.
Yes.
So what is your
that judgment, which according to my submission does not my lord, tally with this fact. My lord, this order has been passed, allowing to absorb this.
Please read now. Read thereafter. Nothing has been placed on record to show the following. Next, page 10.
Page 10. Page 10.
So what was the order passed in those applications? That
In
permanent
that, my lord,
basis.
judgment of page 9. Accordingly, page 9.
Thereafter absorbed. On their objection, such and such. And you have absorbed in compliance with that order, you also absorbed.
I am the railway authority. We are directed. We are directed
No,
to
no.
absorb those
Bhagalpur such
porters.
and such, way 158, as per this direction, you absorb.
Direction, yes, for
Now
those.
they are on the different footing.
Yes.
Since they was engaged as licensed
Yes.
porter,
Yes.
subsequently they started working as parcel porter.
Allegedly, unauthorizedly, because they are not authorized. As per my lord, 1997 order is clearly there. They should relinquish their license as parcel porter.
As licensed, as fully licensed.
Yes, they has to
So,
relinquish their license as a license porter. In that case, they will be considered for parcel porter. And I
should surrender their license.
And I shall show lordship in the document that they have not.
They have not surrendered.
Not.
এই জন্য তো বলতে চাইছি।
So, on the basis of that relayed judgment, this order has been passed. Now, kindly come to my lord.
So first show us that page 12 of the reply.
Lordship. Page 12.
Of the
It
rejoinder.
is annexed in, my lord, the supplementary affidavit on behalf of the respondents. Page 12, my lord.
Not page 12, para 12.
No, it's a page 12, para 12. It's a
The
document
admitted
annex.
position which you just not show. Page 12.
Page 12 is a document dated 25th of July 2013.
Page 12 of what you are showing?
Page 12 of my lord, supplementary affidavit by the respondents.
Affirmed by Tilak Kormokar.
Tilak Kormokar.
So which page are you showing us?
At page, my lord, it is page 15. 15.
Please place the order.
It is Senior Divisional Commercial Manager by SM, that is Station Manager. Subject non-payment of parcel handling subsidy bill 2012-2013. Sir, parcel luggage divisional cash safe etc. of Malda Town Station loading and unloading of done by parcel license porter of the Malda Town Station and for which subsidy bill has to be sanctioned by.
No, is done by parcel stroke license porter.
Yes, but it is not clearly stated. It should be clearly stated because license porters are not at all allowed to carry parcels. It is wrongly.
Please do not repeat that. We have taken note of that. You're saying there are licensed porters entitled to carry the luggages of the passengers and not parcel porters. This is your ground. Now please read this memo. Tribunal says you have admitted. Show us.
No, my lord, this is an official document. I cannot deny what is.
Yes, so what is written in that? Kindly read the order.
My lord, steel porters are doing the work.
No, parcel, luggages, divisional case safe, etc. Please read the letter.
Yes, lordship. And accordingly, small amount as per labor has to be paid.
You are not reading the totality. This is the problem. Please read from the
Parcel
top.
luggage divisional cash safe etc. Malda Town Station loading unloading is done by parcel licensed porters of Malda Town Station and for which subsidy bill has to be sanctioned by Senior Divisional Commercial Manager Malda Town and accordingly small amount as per labor laws has to be paid to them from the divisional as month in every year by but no parcel handling subsidy for the last year 2012-2013 has been sanctioned by the authority concerned yet now. Till porters are doing the work of loading, unloading of parcel luggages and divisional cash safe without getting any payment. If the porters are non-cooperate, the work will be badly hampered and parcel offices as well as divisional cash office will be suffered a lot.
So you admitted that we are utilizing their work, but they are not being paid. Parcel stroke license porter.
My lord, now the question is that it is stated as a general who are the who are the parcels? Who are those porters? Is there the actual parcel porters or license porter? Name has not been given. Not a single name has
No,
been given.
that the tribunal has said you considered.
Yes, considered.
Tribunal
It's stated
said
that
you
to consider.
considered.
Yes.
If they are not there, they are out.
Yes. Absolutely.
That is tribunal has said.
Now, if those persons, the claimed persons, are actually utilized for them, that has to be proved. And this letter does not say anything, my lord. This is my contention.
This letter does not.
This does not.
This is not an admission, according.
Lordship. Lordship. Then, my lord, kindly come to.
Yes.
Page 28 of my petition. There is a letter by Malda Station Manager, Malda Town, to the
Page 28 to the supplementary evidence.
no, my petition. It is a letter by Station Manager, Malda Town, to the Divisional Commercial Manager.
Yes. Page 28.
It's a handwritten letter, my lord. Very illegible. I'm sorry, very illegible. But the main portion can be read out. The following license for
just give me two. Now you are showing page 28 of the writ petition.
No, sir.
Yes, what you are showing?
My lord, this is a letter by Station Manager Malda Town to the Divisional Commercial Manager. Subject: medical examination of licensed porters. Malda Town.
Where you are reading?
My lord, from the top, my lord, to the Divisional Commercial Manager. Then
subject. Yes.
Medical examination of licensed porters, public Malda Town. Then, my lord, the following licensed porters working under me want to transfer their license batch to their respective sons and relatives due to their old age and illness. Then, my lord, names are given. Date is 17/4/2008. In the year 2008, these persons gave their respective badges to their relatives and sons, etc. Next page. This is the list, my lord, who are asking name of the license porter. This is the list.
In which the petitioners are not there.
In this page 29.
Petitioners featured in this list.
Yes, all of them. Page 29.
No, you have not let us understand. Page 28 is the following license porters working under me want to transfer their license to their respective sons and due to their old age and illness.
Some of the
sending the list of license porters who want to hand over the batch for medical examination. For medical examination, my medical fees in here to be deposited. For depositing medical. So these persons are the rich
Some of these persons are petitioners also.
Some.
Yes.
Who have surrendered in their favor of their son or relatives.
Yes, the sons are here, my lord. The petitioners are the sons.
Oh, the petitioners are the sons.
Who have got their
that license porter license to be transferred from the father.
Yes.
Now then, what is this list? Page
Then, my lord, page 29. This is the list of, my lord, license porters. All of them are, my lord, the applicants. Then, my lord.
No, there are 38 applicants. And here is 36.
Names are 36. In page 29, there are 36 names and applicants are 38 because subsequently 2 persons engaged. I'm coming next pages.
Oh, given license.
Yes, as a license porter.
Achha. Yes, Subhash.
Then, my lord, next pages. Page, my lord, 30. My lord, in the year 2014, 1911, 2014 or like that, one Sri Chottu Kumar Roy, he also prayed for getting license in lieu of his father's illness, death.
This is Chotu is applicant number?
Applicant number 36. Applicant number 36. Chottu Kumar Roy. Applicant number 36. Page 32.
Yes.
Lordship, kindly come to page 32. This is, my lord, 9/6/2014. License given to Chottu Kumar Roy.
License porter.
Yes.
Not
They are-
parcel porter.
Not license porter. Lordship. Then next pages, next few pages, my lord, these are those documents which is, my lord, for their from getting license from their father or relative due to old age. Page 33, 34 is name Kishan Mondal. He is 19, applicant number 19. Then Rajesh Rai, applicant number 31, page 35.
No, for what are these letters he has given? For regularization.
No, their father asked to surrender their license and give their sons in lieu of their license, license as a
So the
license holder.
sons are before us.
Sons are before us.
Now that request of the respective fathers was allowed by the railway administration. They were allowed to surrender.
Yes, for not
And
compulsory,
fresh
for
license was
fresh
given
license
to the
issued
son.
to the son. And that is in the year 2008.
Very good.
Page 35, that is also same. Serial number 31 is the son.
Now, Mr. Bera, why you are opposing this application? I don't know. What is the ultimate direction of the tribunal? That treat them similarly with the other applicants?
They will get, my lord, job, my lord, under the railway authority. There is not a, my lord, matter of.
You have done so in respect of the others.
That is a different case. They have, from the beginning, they have worked as a licensed parcel porter. First under the contractor, then after cooperative, then directly. And this is, my lord, they are still under, my lord, license as a license porter.
Achha. We are interrupting you for a moment.
Lordship.
Please come to internal page 3 of the order.
Lordship. Yes.
That the nature of the job of the applicants are performing are perennial and essential for the railway administration. The applicants have acquired temporary status as per provision of such and such under chapter 1. So did you give them temporary status?
No, that is their contention. That is their contention. That
So
is
you
their
did not
allegation
give them any temporary
No.
status.
that
Very
is
good.
their contention that they should get under this act.
All right. Yes.
Then, my lord,
What other document you want to show?
page 39 is also son, serial number 14. Then page 40 he is also son, serial number 23, all 2008 document. On the contrary, their main case is that before 2008 they are working as a parcel porter.
Before?
Before 2009, that means 2008, my lord, they are working as a parcel porter, where they have got their license as a license porter in 2008.
No, that is transfer. Their fathers were working before
It is
that.
not a continuation. It is not a continuation. They had got their fresh license. Or their fathers not in working condition, they got fresh license.
So is it not continuation? No, father was doing that job. Father is sick, now given to the son. According to you, it is not continuation.
It is a kind of compassionate appointment. Compassionate is a fresh. It cannot be said as a continuation.
Acha. Yes. Next.
Also, page 41, is son in the list 8, serial 8, page 42, serial 4, page 43, serial 36, like that. Okay. Oh, it's clear in 2008 they are all got as a license voter in lieu of their fathers.
So how many of them got in 2008?
According to my lord, this report.
Acha, very good. We'll come to that report. Now show us what more you want to show us.
My lord, this is my point. Because that judgment they refer does not tally with the instant fact of the case, and their intention is that before 2009 they were still working as a parcel porter, where they had got their porter license in the 2008.
Now are they working under you still now?
They are working as a license porter. License porter is directly paid by the passengers, not by the railway authority. My lord, license porters get paid by the passengers, and the parcel porters paid by the railway authority. A ledger is maintained, and attendance register is maintained, and accordingly they are being paid.
Yes, come to the report then.
Yes, Lordship, the report says after my lord direction is given, authority called them for my lord physical verification.
After this order? After the order of the tribunal?
Yes.
They were called for physical verification.
For their my lord verification as per my lord law, whether they are eligible.
So you initiated the process in terms of the court order.
We initiated a compliance of the order, subsequently found that it is totally illegal. That's why I decided to file this appeal before your lordships. It is admitted. At the first position, they had decided to
Did
comply.
you communicate to them? Did you communicate to them?
The first line of this order, my lord, lordship, my lord.
First line of which order?
In process of compliance of the Honorable Case, Kolkata.
Which order you are right?
The report, my lord. The report. Initially, they decided to comply with the order. Subsequently, it was found that it was entirely false.
So have they used any exception to this report?
I don't know. I don't know.
We have dealt with. As per
They have
direction,
dealt
we have
with,
dealt with in the affidavit in opposition. We are directed to deal with this report in the affidavit in opposition. We have dealt with.
Yes, place the report.
All the applicants are called with document proof of work performed by them at station in Malda Divisional Railway Station, age proof certificate, educational certificate, police verification, character certificate. All applicants present before the undersigned. Then, my lord, page page 3, paragraph 4, license portal number. It is mentioned that they have been issued no
Paragraph?
for their father's license.
Page,
number.
page?
Page 3 of the report.
Paragraph?
4. 4.
Hmm.
it is mentioned that they have been issued number or transferred their father's license number license to for permission to carrying passengers luggage only as licensed porters. As per railway board letter number etc. The licensed porters should not be utilized for parcel handling work as they are granted license for carrying passengers luggage only. They all have paid license fees up to 31/12/2014. Lordship, kindly mark this point. They have paid till 2014. They have all paid license fees up to 31/12/2014. MR number copy enclosed in a way which is clear that they are licensed porters in the period till up to December 2014. Then the claim before the court that they have issued identity cards for parcel porters and the attendance register is mentioned for the same period. Both statements are contradictory and misguiding as per railway board guidelines. In case they are to be used for handling parcels, they should surrender their fully license, but they have not surrendered their license as yet. License porter dress. As per SS Malda report, they have received the dress from the railways. License porters traveling pass, they all have availed traveling pass as license porters, copy and close. Name, Mithun Mondal. Then my lord, individual given. Mithun Mondal, date of birth, verbally told during verification that he had been performing as parcel porter since 2009. As per record available in the letter number etc. dated all applicants' father were licensed porters. Approximately all applicants applied for transfer of their father's license number in their favor. 17/4/2018.
So what happened? They applied for transfer
That is
from
allowed.
father to son.
Yes, that is allowed. That is
That
allowed.
was allowed.
They're all given license porters license.
So where are those documents?
They are my lord, that document, my lord, is the page 29. This is the list who are the name of the license porters. This list.
Page 29.
29. 36 of 36 Read petitioner.
Where is that list that the persons you have to prepare a chart na out of these 38 applicants? What is it?
রিপোর্টটা তারপরে এই শুরু হলো প্যারাগ্রাফ থেকে
প্যারা 7 এ এদেরকে দিয়ে দিয়েছে আমাদেরকে ছেড়ে। In spite of that difference, all 38 persons. No, no, paragraph 7, you gave the names of all the 38 applicants.
Paragraph 7 of my lord.
বুঝতে পারছো তুমি? 38 জনের মধ্যে সবাই কি বাবার থেকে পেয়েছে? তো পেজ 6 এ আসো। একটু বলছে না, in spite of that. বলছি কতজন সে তো 38 হলো। এখানে কজন? এখানে তো 38 জনেরই নাম দিয়েছে।
এছাড়াও এরা আছে, এরা বলে আছে, এরা ওই ক্লেমটা করে।
Now Lordship sees contradiction of my lord dates. Page 8 of the report. Page 7 of the report. Starting from page 7 of the report. First person, Sunil Kumar Mondal, the first applicant. He was called for my lord, and he, page 8, he stated record of work performed in railway platform. No record submitted by Sunil Kumar Mondal, only verbally told he has been working since March 2014. He is saying that he is working since 2014, where the application says they are working before 2009. Then, my lord,
Sunil was the son.
Sunil is the son.
Shamdeo.
Yes. And he is the first.
Son is working from 2007.
Yes.
Sunil is working from 2014. But prior to that, the father was there.
Father working as his capacity, my lord. Thereafter, he transferred his license.
He transferred the license to the son in
Recommended,
2014.
not transferred.
So
it is
you
recommended.
That's very good. That was accepted from March 2014.
Yes.
And they are working. Sons are working.
Yes, yes.
Yes.
But they are two separate persons and license are separate. Only on the recommendation of the ailing father, son has been given in his place. So it is
Fresh
not a
license.
continuation. It is not a continuation.
That you have
Fresh
said
license.
it is not a continuation.
Yes, it is a fresh license.
Yes.
In the petition, their contention is that before.
So all the persons were allowed given fresh license.
Yes.
Huh? All the persons were given fresh license.
Yes.
Very good. Then ultimately, what was the inference? In your report, ultimately, what did you say?
That they admitted they are working since March 2014, page 8. Then second person, Deepak Mahato, said he is working since March 2014. Everybody says they are working 2014 or 2000 like that.
Now,
But their petition says
what sort of record you expected from them?
they are verbally saying
Just used a one badge to the license portal
they are
and one
verbally.
identical to the parcel
Lordship,
portal.
my contention is that
And you ask them to put your signature or some impression on your register and take money.
But
What sort of record do you want from the portal?
my contention is that, my lord, they have verbally stated they are working since March 2014, where their petition says they are working before 2009. They do not know when since they are working. The petition is based on that. If Lordship kindly come to the first paragraph of the impugned judgment, Lordship can find that, my lord. The petition.
Oh, okay, you proceed. I'm trying to find.
Yes.
Now, yeah.
Page 3 of the impugned judgment. They are working before 2009. Since before 2009. Some of them got fresh license in 2008 and they claim verbally, if it is at all admitted, they are working since March 2014 and they filed the application in 2015. So there is lot of discrepancies, my lord, finding that the department decided to challenge the order.
Kindly come to page 31, the ultimate analysis, page 31 of the report. As per the identical exercise as on 11 July 2022. Read it.
Yes. As per Identical exception the dated 11/7/2020, the department gave a conclusion and finding fact for considering the order of honorable court that he all facts and relevant documents that are produced before the court. But
Where
not
is those
available.
documents? What documents were produced before the court by these persons? Documents they produced was that they took the license from their father.
No. All the facts and relevant documents available before the authority. That are
No,
produced
the
before the court.
documents which were produced before the court
The
are
court,
not
the tribunal.
available. Huh?
Before the tribunal. Court means that's before the tribunal. Tribunal considered those documents and found that those are not adequate. But subsequently, these are the findings before the court, but not available in this office to relate parcel office, etc. It is clear that all the documents are fake and trying to misleading the honorable court and railway to get the railway permanent job. Therefore, all applicants are not eligible to consider as railway employees and can't give some same relief which is given in way 1997. And especially the case is totally different.
তারপরে 2000 সেইটার সময় 97 এর অর্ডারটা হয়েছে। এবার ওইটা এফেক্ট দেওয়ার পরে এবারে ছেলেরা নিয়ে আসছে। Yes.
So what is your actual stand? You are asking that they are licensed voter and parcel voter. In those judgments, the applicant concerned was engaged from the very beginning as parcel. But in the present case, the present applicant engaged as licensed voter. Thereafter, they started working as parcel.
As alleged. It is all
Parcel
allegation.
voter.
It is allegation. It is not proved, it is allegation. But in that earlier case, the referred case, it is an admitted fact they were working as a parcel porter and first under the contractor, then by cooperative. So it is a totally different case.
So you take this plea that you not at all. Now you are saying that they are all their document, they are unable to produce the document, a record. I don't know whether what sort of record will be maintained or preserved by a porter. You are saying that record is not available, no record could not be produced by a porter. Now their documents are fake. So what is your stand?
My lord, my client's stand is clear, my lord. They are given license to work as a licensed porter.
So they are licensed porter.
They are licensed porter. This is the stand of the.
They have never worked as a parcel porter.
Yes.
It is you.
Yes.
So what about your commercial such and such letter?
That letter is in a railway station. They are also licensed porter and parcel porters. They may have stated about those parcel porters who are working there, not these persons. This is the contention of this.
Your own officer admitted that they are working as parcel porter. Where is that?
My lord.
Your own officer.
Yes, that is my lord supplementary affidavit filed by the respondent at page 15. This is stated about they are working parcel porters, and whether these parcel porters are these applicants, that is never stated, and nowhere it is clear whether who are those persons. Only a letter that those persons are not getting payment, but they are in the station. They are also parcel.
Please come to page 27 of your original application, which you showed the distinction.
Page 27
of the writ petition.
Okay.
You have shown us 3 documents. One page 27, another is page 15, and the other is the report which you have filed during course of pendency of this matter. So page 27 says, kindly read the letter in its totality. Kindly refer to your letter dated such and such requesting the board to grant post facto sanction for engaging licensed porters for 8 hours a day for handling railway parcels. The matter has been examined. It has been decided in supersession of board that the license should not be utilized for parcel handling work. But they were utilized.
No. It is of 1997.
Right, 1997. Kindly come to now 2013. Which you are relying, page 15. That says parcel, luggages, divisional, cash safe, etc. Malda loading, unloading is done by parcel as well as licensed porters of Malda. You could not, this is in 2013, you are saying that somewhere being given the batches, somewhere given the identity cards. You cannot distinguish now which is a parcel porter, which is a licensed porter.
But my lord, this document never says, clarifies who are those persons. First my condition, then my lord, this my lord, page 27, it is of
So
the year
this is your stand. Now let us see what they have stated.
1997
So
is relating
all
to
the
different.
voters, so in this case, all the voters were working.
These 36 voters are my lord licensed.
Malda station.
These 36 voters are licensed voters.
License.
Yes, not
Now
parcel.
your officer say that still porters are doing work of loading and unloading of parcel luggage. Parcel. And divisional cash safe without getting any payment.
Yes, my lord. I my lord.
That is why approval was sought for.
Yes, I bow to your lordship, my lord. But this does not say these persons are these 36 persons. Because there are lots of more.
So your only ground is they have not been able to produce any document to show that they are licensed porters. And they are working from 2008.
Yes.
This is your argument that 2008 till date, they have not worked they have not produced any document to show that they are working as porters, say.
As parcel porters. They are licensed porters.
They are licensed porters that they have not document to show that they are working as parcel porters.
Lordship.
But they are working.
Definitely they are working as a licensed porter.
And you say that they are, in the other case, they were licensed as they were parcel porters.
Yes.
There was none in that group who was not a licensed porter, not a parcel porter. That is your argument, no?
In the referred judgment, from the beginning,
all are parcel porters.
Yes. This is the case.
And what you have done with them in terms of the court's order, you have given them regularization.
No.
Those cases. Yes.
The
No,
other,
yes. Referred cases, they are all.
You went up to Supreme Court.
Yes.
So
where is the Supreme Court order?
You are bound.
That is not referred, but we regularized because they are from the beginning. They are working as a.
Show us the Supreme Court order.
Supreme Court.
Supreme Court will simply dismissed. It was affirmed by the Honorable Court. Division bench of this Honorable Court.
Where is that order?
Yes, Lord.
Yes, page 6 of the judgment. In the judgment, page 6, the order was affirmed in WPCT 126 to 2001 by the Honorable High Court at Calcutta, even further by Honorable Apex Court in Civil Appeal number 21911 to 2193 of 2004, referred by the Railways, etc. In this case, they are absorbed because their case is different. They from the beginning they are working as a parcel porter.
Lordship, kindly. This is the order of the apex court. Simply dismiss. Lord, the tribunal's judgment was affirmed by Honorable Justice Kobir and Honorable Justice Jyotirmoy Bhattacharya as their lordships then were.
No, he is claiming that they are not identically situated.
Identical argument was made, Lord. From the judgment, it will appear that identical argument was made that they are licensed porter. Though initially, under contractor, they used to carry parcels. Subsequently, contractor refused to enter into contract with the railway. They formed a cooperative society and they used to work. Then also, cooperative society was also not given the contract. Ultimately, they individually started working as parcel.
You have no document to show that you are working at least.
Yes.
You have no document to show.
Yes, Lord. That's why he has not filed my writ petition. The original application filed before the court, it has not been annexed. I have got the copies, Lord. 3 copies for your lordships. All documents are there. Attendance register, identity card as parcel.
Where have you given?
Lord?
Where have you given to us?
Lord, I am brought it. Because
now you are bringing.
Lord, because Lord, they should have annexed it. They have not annexed anything.
Who is the baby crying? You are the baby who are crying. So it was it not your duty to point out at the exception? He said no document, no record. Now we have to again give him time.
Lord, because he is arguing, Lord, I am not interrupting. I
said, Ghosh, you should have asked your junior that give these 2 copies to him so that he can take instruction.
Lord, he has got this copy.
Whenever you find that some of the vital document has not been annexed, you could have.
We have pointed out, Lord, at the very
leave to file affidavit in opposition or anything like that.
Also, Lord, we have filed, we have annexed.
For the purpose of bringing those documents on record.
Lord, even on in the.
Now, after hearing almost 40 minutes, you are saying document is
Lord,
like
this is
me.
Lord, this is part of the record. This is your lordship. This is the original application.
Oh, it is to be
Oh,
brought on
Mr.
record.
Ghosh, the original application is not before us.
Yes.
Lord, that's why. Have to copy the okay. No. Lord, in the original application, we have made out that, and they have failed to produce a single scrap of paper that our license as license porters was renewed. After 2008, not a single scrap of paper.
No, in course of hearing, Mr. records, all the materials are on record. We didn't understand that you are having another.
And any documents is available to show that you are working as a parcel porter.
Yes.
Any documents is available.
Yes, in the writ petition. In the
Show us where
Lord, kindly see.
Have you got that report, Mr. Ghosh? The report you have got the copy which they filed?
Yes. My lord, kindly see. These are the identity cards granted by the station manager as parcel porters. Lord, your lordship, kindly come to page of the original application. It starts at page 29. From page 24. The persons with photographs. Here's the seal and signature of the station manager. These are the porters, parcel porters identity card. And Lord, they have said that at this relevant time, he was temporarily appointed, he has put his signature. Now, Lord, from the record, it will appear that when these were issued, he was a regular incumbent. Then, Lord, the attendance register, now they have stopped it. And it bears the seal and signature of the railway authorities.
Then what do you say about the report, Mr. Ghosh?
Lord, report has been manufactured from the
You have dealt with the report in your opposition.
Yes, and Lord, kindly see in the before the learned tribunal, they filed their reply. They said that license porters, we are annexing a list of license porters. Nothing was annexed. And that has been recorded by the learned tribunal. Now, Lord, our names have been typed and listed, giving that they are license porters. In the earlier case, also, Lord, the same stand. After the contract was the contractual period ended, they were license porters.
So we are taking on record.
Yes, Lord, kindly.
Huh?
Kindly.
Yes.
Well, kindly give a copy, my lord, because
He is supposed to
authority
get,
has
Lord, they
not- authority
contested
has not
there.
provided any document.
Mr. Beda, please
basis
help
of-
us to solve the problem.
Lord,
This way, now you will say no, it is your application. You are a party
but
to that.
authority has not provided any
Writ
document.
petition is filed by
time of
whom?
filing. Lord,
Writ petition is by you.
Yes.
Lord, but at the time of filing, my lord, authority has not submitted any document. And
First of
also
all,
he has-
we did
also
not.
He has submitted by supplementary with the
No, it was your duty to file.
Yes.
Having heard Mr. Bera,
In the opposition, Lord,
কোথায় এনাদের opposition?
affidavit in opposition, Lord, by mistake,
in opposition to the writ petition.
to their writ petition. Lord, by mistake, the notes of argument were annexed. Subsequently, by supplementary affidavit, I have annexed the
Please go slow. Let us take it one by one.
supplementary affidavit.
কোথায় এই দেখে দিন না এই ওনাদের এভিডেভিট ইন অপোজিশনটা কোথায়?
Lord, this is
এটা তো সাপ্লিমেন্টারি এভিডেভিট দেখছি,
Yes.
রিট পিটিশন দেখছি,
Lord,
এভিডেভিট ইন রিপ্লাই পেলাম, এক্ষুনি তো দেখলাম। হ্যাঁ,
Your
তোরটাই।
affidavit in opposition.
yes.
হ্যাঁ, তোমার কপি আছে?
Lord, can you see 21st June 2023 by Tilak Karmakar?
You have given one copy?
No. And Lord, in the affidavit in opposition, their reply, by mistake it was omitted, but argument was annexed. By supplementary affidavit, I have annexed it.
Okay, we are keeping it.
Everything has been annexed, Lord, except this original application. Everything is on record.
সেম হেডিং দিয়ে দেবে, সেম হেডিং।
Achha, this is the matter for further consideration under the same in the daily supplementary list.
ওতে জেনে নাও In the meantime, while taking instruction, you prepared a list. There are 38 applicants. Which persons were transferred from father to son and which were the fresh incumbents? And what are the records about the records which you have annexed here? You take instruction, we will.
Lord, they have
close-
dealt with. They have dealt with in their reply. All this, nothing new.
Grateful, Lordship.
But I appear for the petition.
Because I appear for the respondent contempt, or something like that. It's contempt.
This is a contempt application. The order, my lord, the violation of which is alleged starts at page 24.
These affidavits are complete.
Yes.
He gave an opposition as well as a supplementary to the opposition.
Yes.
You have replied to both of them. Yes.
Lord, the order of which, my lord, the contempt is alleged starts at page 24. It's dated 12th December 2016. Lord, kindly come to page 33 straight away and take paragraph 16. For the reasons discussed above, we are of the opinion that the allegations contained in the charge sheet do not constitute any misconduct. The order of punishment dated 23rd March 2001 passed by the respondent number 5 along with charge sheet are set aside and quashed. The respondents are directed to grant all consequential benefits to the petitioner as if no disciplinary proceedings was at all initiated against the petitioner. Needless to observe, in the event the petitioner had become entitled to promotion during the period from the date of issuance of the charge sheet till the date of his superannuation on 31st December 2006, the respondent shall notionally treat the petitioner to have been promoted on and from the date from which his immediate junior was promoted in accordance with law, and shall refix the petitioner's scale of pay accordingly and on the basis of the revised last pay of the petitioner. The respondent shall release the arrear pension, gratuity, and other retirement benefits within 8 weeks from the date of communication of this order. So basically, my lord, the direction was that you proceed on the basis that there is a clean slate. Once the disciplinary proceedings is quashed, one has to proceed as if there was no disciplinary proceedings. And
when was the charge sheet date?
Lord, the date
26 March 1990.
26th of March 1990.
Charge sheet.
Yes.
That which two, open mention.
Lord, in fact, your lordships will
1990.
find 90. And Lord, your lordships will find that at page 25.
And when was the punishment order?
Punishment order was 23rd March 2001.
Punishment was removal.
Dismissal.
No, punishment of reduction to
Reduction.
equals-
Sorry.
Reduction.
Reduction of pay.
Reduction of. But Lord, he remained in the same post.
Yes.
Now, my lord, the date 26 March 1990 is also recorded in your lordship's order, page 25, around the middle, your lordships will find.
23rd March.
26th of March 1990.
26 March, that is the charge sheet.
That is the date of the charge sheet, and Lord, he was reduction to the lower stage was also with effect from that date, 26th of March 1990. Now, Lord, after this order was passed, Lord, if your lordships kindly come to page 55.
Yes. 2016. 12
55, the government's communication that government has decided to accept the order. If your lordships will not kindly come to paragraph 3 and 4 of this page 55. Lord, it says in this regard, I am directed to convey the approval of the Honorable Finance Minister for acceptance of the aforesaid order dated 12th December 2016. In view of the above, I am directed to request that so and so may kindly expeditiously implement the aforesaid order dated 12/12/2016. Now, Lord, this was further, Lord, communicated on page 56, 30th May 2017. Kindly come to the first paragraph. Kindly see the last line. It says, I am directed to request you to implement the order immediately as per procedure. I am further directed to inform you that action taken report regarding implementation kindly be communicated to the board. Because it was relating to the income tax, the gentleman was an income tax officer. So, Lord, it says that it should be communicated to the board. Now, Lord, starts the ordeal of this gentleman. If your lordships, my lord, kindly take the supplementary affidavit filed by the petitioner. Because, my lord, during the pendency of this contempt application, something further happened.
Mr. Kaur, kindly please page 57.
57.
56 you showed us.
57.
What is page 57?
57 says that
By the same officer.
By the same officer, Shamol Dotto, he says, enclosed, kindly find here.
Same repetition.
Repetition.
And page 58 is 9th of June. Again repetition. To different officers.
Different officers. It shows that the department has accepted. It's now, Lord, they want to implement the order. So, Lord, kindly take the supplementary affidavit, Lord, which is affirmed by the petitioner on the 13th of August 2018. Has your lordship got that? 13th August 2018.
This is affirmed on
13th August, 13th August 2018 by
11 July 23.
11 July.
Those are, Lord, later affidavits. The one, Lord, which was filed, Lord, immediately after.
একটু দেখে দিন
একটু
সাপ্লিমেন্টারি
দেখবেন এরকম লেখা আছে সাপ্লিমেন্টারি অ্যাফিডেভিট অন বিহাফ অফ দ্য রিট পিটিশনার
এখানে তো this is supplementary evidence on behalf of the alleged contempt.
That is later, Lord, they explain certain.
Yes.
Has your lordship got it? Lord, please come to page 7.
We said to make an attempt to solve the problem. Any fruitful step done?
Lord, nothing has been done. I tell your lordship, my lord's direction was that he should be put back to the same position where his junior was placed. Now, Lord, what has happened is in the first affidavit that they disclosed, they said that this is the best that we can do because, Lord, their case is that it is on the basis of all India recruitment that this seniority is fixed. And therefore, Lord, I was placed just after a gentleman who was promoted in 1997. So between
of West Bengal.
No, from Nagpur, between 90 to 97. Then, Lord, in the reply, we have disclosed, Lord, a policy which says that up to the level of the income tax officer, it is, Lord, on the basis of the region, the eastern region. It's not, Lord, on all India basis. Then, Lord, there is a shift in the stand. They say that we have gone by the recommendation of the Departmental Promotion Committee. Now, Departmental Promotion Committee, according to them, I'll place that, have not held him suitable till the year 1996 or 97. These are all seal cover procedure because, Lord, there was a disciplinary proceedings pending. Charge sheet was there. Seal cover procedure was there. They now open the seal cover procedure and they say that from 92 to 97, we will not give you any promotion. This is the main bone of contention, and your lordships felt that this can be, the decision can be taken because this gentleman is above 80 now.
Now thereafter, what happened?
Nothing. Nothing. They stay where they are. Whatever they have given, they want to stick to that. My contention is that the benefit that he has received from your lordships, that should be given to him. Because he has retired. By the time the matter was taken up by your lordship, he had retired. And taking that into consideration, my lord's direction was given. The issue is that if you are falling back on the Departmental Promotion Committee's recommendation, you are really relying on the charge sheet. And that is the reason why the seal cover procedure was. But the direction is that they should proceed on a clean slate basis.
Mr. Trivedi, why you are raising such point now? You have to proceed as if there is no discipline process.
Correct.
But it is the order under contempt and you have accepted this order.
Yes.
So you as if, so why, if anything adverse remain in the seal cover proceeding, that is not nullity in the eye of.
Well, may I? May
Yes.
I?
Yes.
I'll be putting the cart before the horse because my learned senior friend has not completed. I would have been benefited by his argument. While
Mr. Kaur, you finish. Let him finish.
Yes, Mr. That's why I'm saying. Let him finish.
What you want to show us?
Lord, kindly take the supplementary affidavit.
Yes.
Come to Lord, page 7, paragraph 4.
Page 7, paragraph 4.
Yes, 4, Lord, starts at page 6. Please come to page 7.
Yes.
Kindly, Lord, come to the last paragraph. This is with regard to who is the next person junior.
Page 7, last paragraph.
Last paragraph. The
Yes.
charge sheet against the petitioner was issued on.
Please.
I'm so sorry.
Yes.
Last paragraph. The charge sheet against the petitioner was issued on 26 March 1990 and the same has been quashed by the Honorable Court. Therefore, as per order of the Honorable Court, considering as if there was no disciplinary proceedings against the petitioner has become entitled to get promotion in the year 1990 against the vacancy of 1991, as and when the immediate junior of the petitioner, Sri Devnath Mukhopadhyay, Civil Court number such and such, got promotion to the post of Assistant Commissioner of Income Tax 27 March 1991. But deliberately, the notional effect of promotion in the post of Assistant Commissioner was given to the petitioner against the year 96-1997, which is a clear violation of the solemn order of the Honorable Court. It is stated, paragraph 5, that up to the post of Income Tax Officer, Group B post, the gradation list or seniority post is maintained as per the state or region wise, for example, West Bengal, Nagpur, Pune, etc. After promotion from the post of Income Tax Officer ITO to the post of Assistant Commissioner of Income Tax, a post of gradation list is maintained on all India basis. So therefore, Assistant Commissioner onwards, Lord, it is all India. Then it says, Sri A.S. Titas was an income tax officer in Nagpur region and K. Raghavan was an income tax officer of Kerala region. But the petitioner and his immediate junior, Sri Devnath Mukhopadhyay, civil court such and such, was an income tax officer in West Bengal region. So the promotion of Sri Titas in the year 97 has no relevance to the case of the petitioner. The petitioner's promotion has to be guided by his next junior. Then Lord, please come to Lord, first kindly see page 27. What is the fixation that has been allowed?
Page 27.
27 of the Lord supplementary affidavit. Kindly Lord come to 27.
No, page 26 is the order, 3rd January 2018.
Yes, sorry. Yes, Lord, I made a mistake. It says, in compliance with the order, Satyendra Kumar Rai is hereby promoted to the grade of Assistant Commissioner Income Tax, notionally with effect from 10th April against the vacancy of the year 96-97. And it says, consequent upon his notional promotion to the grade of ACIT for the panel year 96-97, he is placed at serial number 26A, below Sri Titas and above Raghavan.
No, where is this Devnath Mukhopadhyay?
Devnath Mukhopadhyay. He was promoted in 1991. And
you are saying he was the last junior.
Yes. Kindly see page 47. This is the position now in the gradation list.
So Devnath
has gone up as 949. And Lord, I have remained below at page 48. Satyendra Kumar Rai.
You are
page 47, your lordship is seeing.
Yes.
First name is Devendra Mukhopadhyay. Kindly see West Bengal. His 90 date of appointment to Group A is 27 March 91. I'm sorry, Lord.
Date of appointment. You are wanting it from that date.
Yes.
91. So Group A, that is Assistant Commissioner.
Yes.
Now, where is the name of this this Titas? Where is the name of this Titas?
Titas is not going to be here because Lord, this is West Bengal.
No, in the combined list, the page 46 says that it is Indian Revenue Service Civil List 2001.
Titas blood is
this is a civil list or pan India because there are West Bengal, Bihar. So where is Titas?
Titas blood is not here. Titas doesn't feature here. In this list, he is not there, but I can. I've not annexed.
Satyendra is at 1067.
Yes.
So you have been given. Have they given you? No, Satyendra, but the column does not tally. Satyendra, page 48. These columns are name and date of birth. Date of regular appointment.
Yes, so this is not the continuation page. This is on some other page.
Now we are wanting to know, Mr.
I followed.
That in the pan India list, what is the position of Devnath, Titas, and the petitioner?
I will apprise your lordship. I'm taking note of this point. So, Lord, let us proceed on this basis that Lord 27 March 91 was his promotion, Devnath Mukhopadhyay. And Lord, 27 June 2001, he was appointed as the additional commissioner of income tax.
And you were given from 27 March 91, most probably.
No,
you are given from 96.
97.
97.
97. Kindly, Lord, come back to.
That is paragraph 4.
4, Lord, page 7, 27 March. This is.
Got promotion to as a 27, but deliberately notion in the post of as was given to the petitioner from 96-97.
Yes.
So Titas must have been given in 96-97.
Titas, Lord, I'll just find out. Lord, I'll give your lordship, Lord, the exact date. Titas's position. I'll give your lordship the date.
What kind of features in 1997?
Lord,
Huh?
May I just, in the meantime, I'm looking for that. Kindly, my lord, come back to page 27. 26, your lordship has noted.
26.
Titas and Raghavan, my lord, I'll just get back. But please come to page 27.
Page 27, yes.
27.
Huh.
There is a chart. Kindly see 9th April 1997. Has your lordship got that? That's the first date.
Yes.
That is the date when I become, that was the date as ITO.
Huh?
This is the revised,
ITO.
This is the revised fixation. ITO. Then 10th April 1997, that's my date of promotion. I become ACIT. Has your lordship found that?
Yes.
On the right hand side, remarks column.
So this promotion you wanted from 1990 with Devnath.
With Devnath. At par with Devnath. Whenever Devnath is promoted anywhere, that's your lordship's
So
judgment.
Devnath was promoted on
91.
1991. Now what is their stand?
Yes. Now, my lord, just one more paragraph. Kindly come to page 11 of the supplementary affidavit.
Page 11.
Yes. I've given a calculation.
এই স্টেপলারটা দিন একটু।
Sorry, এটা একটু খুঁজে রাখো।
Yes.
Lord, I have page 11, Lord, I have given a chart. If I was promoted in 91, what would have been the situation with Devnath Mukhopadhyay? Your lordships may kindly come to the chart. Assistant Commissioner of Income Tax, 27 March 1991. Has your lordship found that? Then, Lord, Senior Scale Assistant Commissioner of Income Tax, so and so, 1st October 1994. And then, Lord, Joint Commissioner, 27 June 2001. And Lord, Additional Commissioner on 1st January 2003. I retired on 1st January 2006. So, Lord, this is how, if Devnath Mukhopadhyay is followed, this is what the benefit that I get. And this is what I have said. And your lordships may kindly also take note of page 47. Sorry, page 47, 48, I have shown to your lordships. Yes. Now, Lord, please take the affidavit in opposition. This is Bimolendu Tudu, who has affirmed it on 18th of May 2023.
We take the opposition.
Opposition to the contempt and the supplementary affidavit. No, supplementary. Not supplementary. The contempt application. Sorry, contempt. Please come to 18th.
They have also filed a supplementary opposition.
They have filed a supplementary opposition later.
So you are showing us the first opposition.
First opposition.
Yes.
In January.
First opposition is 18 January.
18th of, kindly give me 1 minute.
2011.
It is 18th of May 2023.
হ্যাঁ,
একটু দেখে দিন না, চর্চা পাচ্ছেন না।
Yes. Yes.
Yes.
Yes, Mr. Kaur.
Lord, please come to page 6 of the affidavit in opposition.
Yes.
Lord, around the middle of that page, there is a sentence, Lord, starting with the word, however, the recommendation. Kindly, Lord, take
However,
the
the recommendation.
yes, just take, Lord, one sentence above that. It was in fact found, has your Lordship, that Sri Mukhopadhyay, being his junior, was granted promotion with effect from 27 March 1991. So this fact is admitted. However, the recommendation of DPC in respect of the petitioner was kept in a seal cover due to the withheld vigilance status. In the light of the order dated 12/12/2016, the respective seal cover recommendations of DPC states as follows. Having examined the character role of Sri Satyendra Kumar Rai, against whom vigilance case is pending, the Departmental Promotion Committee assessed him as good. Despite vigilance case, assessed him as good. On the basis of this assessment, the committee recommended that his name could not be included in the panel for want of sufficient number of vacancies, as officers with better grading were available. Because better grading of the officers were available in view of his vigilance case, therefore, Lord, he was assessed as good.
This vigilance case was the subject
matter of the
charge sheet.
Charge sheet. Lord, these vigilance cases were started because, Lord, the department found that maximum order, assessment order that he has passed, the assessees have preferred an appeal and most of them got reversed.
Please read it. The committee recommended that his name could not be included in the panel for want of sufficient number of vacancies, as officers with better grading were available.
So, Lord, better grading was available because of the vigilance case. He was assessed as good, not very good or anything else. It is evident from the, may I just read, Lord, the next sentence? That will be more.
Yes.
It is evident from the recommendation that DPC did not recommend the petitioner for such promotion. Hence, he could not be promoted as ACIT with effect from 27 March 1991. Now, Lord, when the matter was being heard, and your Lordship's Lord said that you consider him with a clean slate, can they, in the teeth of that order, go back to these recommendations, which are based on the criminal case, vigilance case, etc.? Disciplinary proceedings based on vigilance case.
Now, this seal cover was done on when?
This seal cover must have been done, Lord, after, no, 1990 onwards.
1990 onwards, no?
Your Lordships will find that just few lines.
You said that this better grading was available is juxtaposed to this vigilance case.
Yes.
That since the vigilance case was there,
yes,
there were the committee found other better graded officers.
Officers who didn't have vigilance cases or not disciplinary proceedings.
Then how it was said that it should be good? On what basis they said?
Not very good. Gradation, Lord, one is good, one is very good, the other is excellent, outstanding.
Yes.
Because, Lord, it says, Lord, kindly see the DPC is finding once again. I'll just read it. Having examined the character role of Sri Satyendra Kumar Rai, against whom vigilance case is pending, the Departmental Promotional Committee assessed him as good. On the basis of this assessment, committee recommended that his name could not be included in the panel for want of sufficient number of vacancies, as officers with better grading were available.
Oh, okay.
And Lord, this DPC, the vacancy.
God, come tomorrow.
Wait. Sorry. I just placed, Lord, the explanation that has come in the supplementary affidavit. This is more or less I placed maybe one more page.
কালকে কিংবা পরশু যেদিন
হ্যাঁ পরশুদিন ঠিক পরশুদিন রাখুন কারণ আমি তাহলে ওইটা নিয়ে আসবো ঠিক আছে ওটা
But we'll try to collect. Not although it is admitted that Divanath Mukhopadhyay was the
No,
next.
we want to see otherwise
Yes.
because my brother won't be there for 2 weeks. My brother will be in circuit.
তাহলে কালকে
So if you cannot bring it within this week.
No, of course. We will come. Day after tomorrow, your lordship is suggesting I will come back on day after tomorrow. No, I just wanted to get that book. Lord, there is a booklet. As to this, that.
No, Mr. Trivedi, do you have that gradation list or whatever it is showing the position of Devnath and Titus?
But we'll get it. But that is my lord, our defense is twofold, my lord. I'm just wasting my lord's time 30 seconds. My lord. My defense is twofold, my lord. One is that this DCP has nothing to do with the charge sheet. This is bereft. That I will show to my lords. If I can.
DPC has
Nothing to do. What my learned senior friend is trying to impress, that the DPC which was created, it was under the light or the dark light of my vigilance. So they are bereft of each other. Because it was kept in seal cover, it is something else. One. Secondly, that as far
was in reference to any other vigilance case. That DPC was.
It has nothing to do with any vigilance. DCP is a departmental assessment.
You refer to that.
My lord, I'm just saying we will amplify on that. And my lord, since it has fallen from my lord, we'll get that details, my lord. So in that case, my lord takes it up on Thursday, my lord. Will it be my lord's?
My brother will be leaving now. We cannot take it up again for the next 2 weeks. This is the problem. We can.
My problem is that my client is ailing. He's 80 plus. Lord, I would much rather.
All right, day after tomorrow, come back.
No, Lord, I shall.
Please make an endeavor, both of
Yes,
you.
Lord, I will.
You can finish it off. We will.
Yes.
Day after tomorrow, দিতে পারবে? আচ্ছা।
ওনার কাছে বলে আছে নিয়ে আসবো
নেই না? শেষ হবে। কালকে কি দুটোর সময় আছে? নয় 10 তারিখ ঠিক না? 9-10 তারিখ। না তা তুমি এইটাকে কালকের লিস্টে কি মোশনস অনেক আছে? তাহলে মোশনস এর পরেই এটাকে দিয়ে দিবে। এই কন্টেম্পট অ্যাপ্লিকেশনটা ইমিডিয়েটলি আফটার দি মোশনস কি ফাইল হয়েছে দেখে নাও। Tomorrow will you be able to get those, Mr. Kord?
চেষ্টা করছি হয়ে যাবে
We'll make a sincere attempt. Lord, keep it tomorrow because your lordship's convenience is very important. Let's not try and get it.
You have to complete your arguments. You have to pass the order, na? All right, day after tomorrow, this will be after motions. Please get in touch with the. Due to paucity of time, Mr. Kord, learned advocate appearing for the petitioner. Now, for this the matter.
I'm great.